She was a cop. She was a new mother. She was shot in the chest. And she is the one on trial. Welcome to Defense Diaries. I'm Bob Motta. Let's check out today's hearing. Good morning and surprise. Allie and I was pretty certain that Mel was going to be covering this. So I'm like, yeah, we'll do a recap later. Apparently, I don't know what's going on with Mel. She probably has some other stuff going on. She wasn't covering it. We were watching the Afro Man, the end of the Afro Man trial.
Wow, real bad freeze there.
Wow. I mean, she probably doesn't appreciate it. Hopefully she doesn't check out this live. She'll be like, did you really start your live with me doing that at council table? Totally inadvertent. All right. So we are late. We're going to watch this. Today is the trial readiness hearing that they're going to have, just making sure that all the ducks are in a row, handling any last second issues that might have arisen, all the housekeeping stuff. That's what's going to be going on today. Because as you may or may not know, trial is set to start on March 23rd. I'm curious, this might be a good time if Bradl was so inclined, or frankly, if Kelsey was so inclined to waive jury and go bench. I don't know. This might be a good time to let them know, them being the courts, but let's give it a start.
They got 10 days, right? Oh, no.
Starts next week.
Oh. Yeah, YouTube's X isn't working.
I think my awesome Afro Man tweets like broke Twitter. Maybe not.
All right, please. Court now open.
Good morning, Your Honor.
Good morning.
March 18th, 2026, Courtroom 4, Lawrence Superior Court. The Honorable Justice Jeff Karp presiding. Calling the criminal matter of Commonwealth versus Kelsey Fitzsimmons, 2025, 77 CR 311, scheduled today for a trial readiness conference. Could counsel please identify themselves for the record?
Good morning, Your Honor. James Cooper, Associate on behalf of the Commonwealth.
Hold on. Sorry. I'm going to boost the sound a tad. Seems a little low to me. Okay.
Good morning.
Good morning, Your Honor.
Good morning, Your Honor. Timothy Bradl on behalf of Kelsey Fitzsimmons.
Good morning, Your Honor. Martha Coakley on behalf of Kelsey Fitzsimmons.
Good morning. Good morning, Mr. Fitzsimmons. You folks can have a seat.
And if I may, Judge, I have Ms. Healy with me, or actually stays at council.
Yeah. I'm sorry. Her name again?
Ms. Healy, Courtney Healy, Your Honor. Our paralegal.
Okay. Yeah, that's fine.
Thank you so much.
Okay. So we're really on to discuss the juror questionnaire, the draft of the juror questionnaire that I emailed you folks on Friday. I did have some preliminary questions. If you don't mind, I think these are fairly quick. So let me just ask about trial readiness. Are both sides ready to begin impanelment on Monday and then start the trial the morning after we get our 14th juror?
Yes. Okay. Judge, on that point, I don't want to waste a lot of the court's time. So just a suggestion is, could we do the rest of the housekeeping matters, take a quick break, and then put the questionnaire to the end? Because we may not do it. It may be a moot point.
Okay. I actually, that's one, you're ahead of me.
Okay. Big tell, right? Everybody, I don't know who planted the seed about Judge Karp not presiding over this trial. It would be insane on the eve of trial for them to pull Karp off this trial. I don't know who planted that seed, but I'm here to tell you I would not be concerned with that happening at all. That's not how this thing works. If you're listening to non-lawyers saying that kind of stuff because he's not assigned on a docket, he's the presiding judge at this point. He's made substantive rulings in the case. The thing is set to go to trial next week. They're not going to switch judges. Okay? I just, it's been killing me reading those comments. Like, if he's still gonna, like everything is not nefarious in the world. I understand how our beloved Massachusetts residents feel about their judicial system. I get it. But in this particular circumstance, I feel extremely confident that Judge Karp will be presiding over this trial. So at any rate, Bradl just gave it to us. So Bradl, what he said specifically, let's move the jury questionnaire to the end of this because it may be moot.
Aha.
That's all you need to know. That's where Bradl's head is. That's where Bradl's head is. We'll click it back just so you can hear it again.
You know, I don't want to waste a lot of the court's time. So just a suggestion is, could we do the rest of the housekeeping matters, take a quick break, and then put the questionnaire to the end? Because we may not do it. It may be a moot point.
Okay, I actually, that's one, you're ahead of me on my agenda, because I was going to, let me just skip to that item, right, what you're speaking about. So what I was going to say, mention to you, is that I believe at the last hearing you mentioned, Mr. Bradl, the possibility of Ms. Fitzsimmons waiving her right to a jury trial.
Yes.
And what I was going to say to you, and we'll give you some time, we'll take a break and give you some time to talk about it, but what I was going to mention to you is that I really want to, it appears to me that the law, both the statute and the rule, give me some discretion as to whether I would grant the waiver. And the only reason I would, well, let me just tell you my thinking is I would like to do everything possible to avoid having to bring 70-ish jurors in on Monday if it's going to be a waiver. So what I was going to say to you is I would need a decision by Friday, but it sounds as though maybe you'll want to talk with your client about that.
You, Philly.
Today, so
Exactly. We were going to have to take like 5 minutes and then.
We'll when we get to that point, you'll
Give you plenty of time.
All right, a couple other quick things. So the trial, we're trying to coordinate having the trial be held in courtroom 2 on the 2nd floor, just to accommodate more audience and media members than we can fit in this courtroom, because as an example, the camera that is set up is actually, I think, either in the jury box or just too close for comfort. So our hope is that the trial will occur, whether it's bench or jury, down in the courtroom number 2. We are still working on some logistics at our end, and you folks, especially the Commonwealth, may have some logistics that you'll need to go over with Mr. Limine. If the logistics cannot be overcome, then they can't be overcome. But at least that would be my preference, is to have a bigger courtroom than a larger courtroom is here.
Hey, share the stream, guys. I can't post on X. I don't know what's going on.
I will need, if there's going to be a juror questionnaire, I'm still missing Dr. Zeisel's address, which used to be in Brookline. I'm assuming.
Oh, wait, it worked.
He's still in Brookline?
That's another development, Judge. We're actually not going to call Dr. Zezel.
Okay, all right. But so would well, we'll get to it later. I'll also need, when and if we get to it, I need an address for Charles DeChara. Is that Commonwealth's witness or the?
No, it's the defense put him on there, but I'm working on that actually.
You're working on the address?
Yeah.
But it's a defense witness?
It was an independent investigation that was done by the North Andover police, and they created a report.
Oh,
I wasn't going to call him. He put him on the witness list. But I think I probably have better quote unquote connections to get an address. So.
Yeah, just the town or the name of the business or something sooner than later. All right, so those were the only two items that I missed. And by the way, I did take out Ms. Fitzsimmons as being listed as a witness. So you're going to actually see on the next version that in order to save me having to renumber, I just put number 20 intentionally omitted. There's no reason to, and I know why you did it, both sides did it, but there's no reason to put Ms. Fitzsimmons. There's going to be plenty of questions about knowledge about Ms. Fitzsimmons and the case that her name won't be necessary on there. A couple other questions. One is on the scram device. Is that probation?
Yes.
Oh,
Yes.
hi, how are you?
Good.
Do you mind just stating your name for the record?
Yes, Your Honor, probation officer Tony Taylor.
Okay, and Officer Kidder, well, everyone, let me just think out loud for a moment. I'm concerned, or should I be concerned, that Ms. Fitzsimmons is going to be alerted during the trial to blow into a scram device? Yes.
Yes, Your Honor, I did speak to my supervisor in regards to the scram earlier this morning, and I was going to contact electronic monitoring to make sure that it did not go off during the time that she was in the courthouse.
Okay. All right, I just, I don't know what I don't know. And all I know about the scram device is what the probation officer at the last hearing told me about. So I just want to make sure, I'm sure that you folks are out in front of this, but let's just make sure that it's not visible to jurors or, and that she isn't seen lugging it around or going into it in the courthouse. It's still a small courthouse, right? So if probation can do something to shut it off during the court proceedings, that would be great. Actually, better yet, during the time when Ms. Fitzsimmons will be near or in this building, and again, near even coming from parking, I just don't want to take a chance that a juror is going to, potential juror is going to see her blowing into the screen.
Yes, Your Honor, I will make sure.
All right. All right, and then last thing is, so I'm already thinking about jury instructions, whether it's jury instructions or whether it's instructions to myself. And so there's two theories of assault, right? Or two ways of assault can be committed. An attempted battery, a threatened battery. Is this one, the other, or both? Or what is
Both.
this? Both.
Is that what it's,
That's
in the-
all I wanted to know whether you did. Okay, so really, I don't have anything else. There is, Commonwealth filed a motion. So is that something that you want to do before we break? Does that make sense?
Yeah, the Commonwealth filed a motion in limine on Friday, I believe, or over the weekend, I'm sorry. The Commonwealth filed a motion in limine seeking to admit a number of text messages between the defendant and her ex-fiance, Mr. Limine. There's text messages that we would seek to introduce span the day of the shooting, so just the day of.
I'm sorry, just let me interrupt, all right? So just setting it up for the record. So you're referring to paper 82, which is the Commonwealth's motion to eliminate to admit the defendant's text messages from the day of the assault. I did have some trouble reading them, but then I was given a better copy. But let me just ask, just yes or no, Mr. Bradl, is there an objection to the motion?
There is.
Okay, all right, so now I'll hear you. Thank you.
So the Commonwealth suggests that the one thing that I think everyone can agree upon in this case is that the defendant's state of mind on June 30th, 2025 is the most relevant issue before the jury. And what more insight into the defendant's state of mind on the question can we get than her text messages with Mr. Limine? I would suggest the Commonwealth is not seeking to admit over the weekend, over a period of time, but literally it is from the morning of June 30th through the afternoon, approximately sometime after 2 o'clock on June 30th. I would suggest that generally they're not particularly prejudicial, but they are relevant because they show that she is angry, upset, at times despondent, and clearly having a conflict with Mr. Olayan, and this is prior to the service.
He's not the victim. The fuck?
By the North Andover police.
He's not the victim.
So your theory is they show what? Anger? What else?
They show her state of mind. And the
No, I know that, but you
What state of mind?
gave me a laundry list of what the state of mind you say can be gleaned from these.
From a Commonwealth perspective, she's angry at Mr. Olayan for not.
So
Mr. Olayan has clearly is not at the house, has separated from her for a period of time, and she is angry and is trying to get him to come back to the house and trying
So?
to reconcile. So I would suggest that that is consistent with the Commonwealth theory that this shooting happened when the defendant heard Mr. Olayan.
oh please.
Shooting happened when-
He can't even wrap his mind around it.
Defendant raising her gun towards Patrick Noonan, and Patrick Noonan, in response, shooting the defendant happened at the time when Mr. Olayan was in the house.
Okay, so I'm sorry, are you saying that it's the Commonwealth's theory that Miss
Just laugh.
Fitzsimmons heard Mr. Olayan in the house and then reacted to it, or?
That's one of the Commonwealth theories, yes.
That's the stupidest thing I ever heard, counsel.
It would be something to the effect of the defendant said, keep him away from me.
Like in this exchange in the bedroom or near the bedroom or whatever.
Ay.
I'm sorry, anything else?
No, I would suggest that it's
Your mic is really, really low. I don't know. Is Allie's mic low for you guys? I can
You sound
barely
like
hear
you're
her.
screaming in my ear.
I do? Dang it.
Yeah.
All right, hold on.
I mean, I think I have mine set to auto.
Oh my goodness. Yeah, it was up to like 144. What? It's weird. It's the
Yeah,
second
just-
time it's done that. Apologies if I blew your eardrums out of your skulls.
So if no one had heard me, I was saying this is fucking preposterous. Elayan's not the victim. And it seems like the judge can't even wrap his mind around the stupidity that this woman is spitting out there. She just tried to wrap it up. She just tried to put like a little kind of connection, but oh, the dog scared the shit out of me. Like snorted next to me. Like by saying, oh, but she said words along the lines of keep him away from me, and then pointed the gun at someone that she was not angry at. Okay. All right, let's see how this plays out.
And speaking of Justin Olayan, Broken Baker was spreading the good work. He had sent me, along with several other creators, a series of recorded voice calls, telephone calls of Justin after this hearing. We're going to give him a listen. We're going to give him a listen.
Ooh, I'm excited.
Yeah, it looks to be about 8 calls.
Wow.
8 calls. I have not listened to him yet. It'll be first blush for Allie and I. I don't know what the content is. I don't know who he's speaking to. I don't know any of that. You guys in chat probably know more than Allie and I do, but we're going to give him a listen at the end of this hearing.
Thank you, Baker.
Thank you, Baker.
certainly more probative than prejudicial if you just look at the text.
Probative of what? Asshat.
Oh,
outrageous
wow.
in the text, but it does go to show our data.
That makes
So,
sense.
And how would these be admitted? They'd be admitted in this format?
Yes.
Like just, and how are they?
Authenticated.
How did the Commonwealth obtain these?
The Commonwealth prepped Mr. Olayan on Friday, and he provided them to the Commonwealth.
That's hearsay.
So
Better-
they provided, they authenticated through Mr. Olayan. He would explain that he received.
That's
them
not hearsay,
on
but
his phone, and that this is a very accurate depiction of the screenshots he took from his phone of the text messages he had that day with the defendant.
And is this all of the text messages that they exchanged on that day, or is this a portion of them?
No, that is, from that day, that is all.
defense. What do you have to say to this bullshit?
All right, and the other thing that, if we can just flag it and we'll circle back, is that I provisionally impounded, so I was out on Monday when this was filed, I believe, and I provisionally.
I'm sorry to interrupt the stream again. If you're coming in late, we are behind. Oh, Allie and I thought that Melanie was going to be covering this thing for sure. We usually we're going to cover the trial, but in terms of like hearings like this, so we're like, you know what? Let's watch Afro Man. Tracy hit us up. She's like, nobody's covering this. I think law girls, not attorneys, are. So we came in late. We decided to do the public service, make sure that we got Kelsey's case out there to the public. So that's why we jumped on. So we are behind time. It may or may not be going anymore, but yeah, we are behind time, but it was live this morning. So, and it started late.
Oops, Baker's covering it.
Oh, he is?
Yeah.
The motion and the exhibit being text
Sorry, Baker.
messages.
I didn't know.
I saw that Mr. Bradl had requested it in an email or something, so I just want to, because it's provisional, I want to discuss how we do that.
Second
all right,
weekend.
And, all right, so let me hear from Mr. Bradl.
Thank you very much. Judge, so evidence has to have a rational tendency
Yeah.
to prove a proposition in the case
Yeah.
for relevancy. And it's not a rational connection to say that because Kelsey was supposedly mad at Justin on this day, that she's going to shoot her colleague from North Andover. It's like if I'm mad at Charlie from Mass Live for reporting, and then I run into the law girls later on,
No.
I'm not going to
Shout out.
do anything bad to the law girls because I'm mad at Charlie.
You must be the law girl. I am not on social media or anything with that.
That's awesome.
Don't assume I know who the folks are, but well.
Congratulations,
and
law
you
girls.
refer to another
Influx
member-
coming your way.
Yes, this is the law girl. They have their own blog. And it's just a rational thing. I mean, it's just, this just opens the door to the Justin stuff that is completely irrelevant to whether or not she assaulted Noonan in the bedroom when it was just the two of them. There's no relevance to it, to this charge. And there is prejudice. There is unfair prejudice.
Yeah.
To show that she's in a fight with her boyfriend. Nobody wants to be judged on
propensity.
that, Proposition A, when Proposition B is completely different, that we're here for trial on.
Apples and
So
oranges.
I just don't see the connection. Her state of mind about Justin is not her state of mind about Noonan. And there's just no possible rational tendency in terms of relevance that because she's mad at some totally different guy, that she's going to hurt her colleague and friend from work.
Well, here's the thing.
Oh,
is
Judge, don't break my heart.
perhaps I need to do a analysis under Rule
403.
403, but I mean, it's relevant in the sense that the Commonwealth has to prove intent. It is a general intent, and it's also relevant because I think that Ms. Fitzsimmons has put her state of mind somewhat at issue because there's information, at least that I've heard, that that if she had the gun, she didn't point it at the officer, she pointed it at herself because of her mental state. So wouldn't this
No.
be evidence, again, just not for the truth, but just to show her mental state at the time of the.
Absolutely not.
So my strategy on that, and I'm happy to share it, is just that there's enough from the content of the restraining order that without having to open the door to mini trials about who was right between her and Justin and what are they fighting about and what's going on and what are the details of that. She just received a restraining order that said, as I said the other day, I won't go into it again, all the things that order implied were horrible, tragic, and awful. And that prompted her to have a sad, brief moment of intent to self-harm. And thankfully it didn't happen.
Let me say this. I read these text messages and I arguably thought that they helped you, frankly, because
Sure.
I know that the Commonwealth sees anger in them. And yeah, I think it could show that. But
I agree with you.
But they also arguably show It's what they don't discuss, I guess. I'll just leave it at that.
And
So-
that's my point, Judge, is that it's opening doors. It's like opening more doors about this when we're not intending on opening that door. And, you know, I don't want to have that thing where, oh, well, this helps us, but then that might hurt us, and then this might help us, and then we're having a mini trial about Justin versus Kelsey.
But Mr. Bradl, with all due respect, you folks put Mr. Allen front and center. Maybe you changed your mind about that. It sounds like maybe in the last year and a half you have, which you have a right to do that, obviously, but he's been pretty prominent, and their relationship has been pretty prominent from the defense's perspective, from what I've heard, all right, and see.
So if I can speak to that, I don't need to talk about it.
No, go ahead.
Sorry. So Judge, we have to play both sides of that street because the government is pushing that. The government wanted to put, you saw that prior motion in limine where they had these 4 things that are like, you know, this is judgment day for Kelsey's entire life. You know, the government wanted to open this case up to Justin and Kelsey and what happened in Maine and all this other stuff, you know, and I think the government's backed off of that, but the government started that fight and I have to match it. I have to be ready if, out of an abundance of caution, if the government was going to go down that road, I got to be ready. So that's, you know, the Justin stuff gets, has to be vetted. And I have to be ready if he's called and if he is a witness. You know, I have to be ready on both sides. My preference is that we have an economic trial here where, you know, the issue is Kelsey gets this restraining order full of horrible nightmares. She acts accordingly on it. The government puts their case in, we put our case in, and the fact finder decides. You know?
So, but don't these text messages help your client show that? Because I'm not, again, listen, the Commonwealth, you know your case, both sides. I only know what little I know from the file.
Sure.
But when I read these, yes, maybe there is anger, maybe you could say that, but there's also an absence of any concern for her mental well-being by Mr. A. Allen, any really any information, any comments made by Ms. Fitzsimmons that would lead one to believe that she was suffering emotionally at this time, which would, so I guess that's part of the analysis of what when I'm doing the 403 analysis is on the prejudice of the defendant. I'm not sure that I see a lot, but I can tell you this is that there is one passage in here that I thought I saw that where he said something about her allegedly hitting him or something, and
It's on the first page, Your Honor, the 4th bubble on the right.
No, y'all. We're watching on Boston 10. Closed captions are not working. As you can hear, so I've got 2 boosters on. I've got the YouTube specific streaming booster, but I've also got an additional booster. So I've got it boosted twice, which is if we don't adjust our mics, that's why occasionally we blow your eardrums out, because we have the stream boosted. There's not much I can do about it. I hope they get this resolved, because the last hearing was pretty clear to me. Like the audio was much, much better. So I've got this pretty much cranked as high as I can. We're already getting some distortion, which doesn't sound great, but just so you guys know, it's the court's audio, not our audio. That's not great, because we can fluctuate our sound on our mics. But when we use boosters, we are blaring and blowing your eardrums out. So we're just going to have to kind of power through. Unfortunately, no captions are available. We're just going to have to really lean in and listen hard.
her allegedly hitting him or something, and
It's on the first page, Your Honor, the 4th bubble on the right.
So I give you a proffer on that. And so I appreciate what you're saying, Judge, about on its face, though, the general gist of those text messages would help in the sense of the distraught mindset. However, If that's where it sits, I can live with that in terms of but we'll talk about the hitting thing. But I'm looking at this like, I feel like the government's gonna try to say that this opens more doors. And I don't wanna go down this road of like, going down, Justin versus Kelsey and everything in Kelsey's past going back to two other ex-boyfriends. Like, that's where I wanna guard against.
Commonwealth said 2 hearings ago, this is a simple case. You said at last hearing, and it will be a simple case, but it's still simple in the sense of what happened in the bedroom.
Right.
And it seems to me that what Ms. Fitzsimmons was thinking at the time is absolutely relevant. And then her state of mind and the hours leading up to it would be relevant too. And again, let me say this. I'm making an observation.
Hey, you?
Yep. That's what I think of the judge's point.
What? That you belched.
No, that's what I think. That's what I think of the judge's point. I had my camera off, so you just got my sound effect.
Wow.
That's what I think.
thought you just ripped a huge belch right out of your mouth. Wow. Yeah, the court audio is not good. I'll flip it back.
I
Yeah,
just don't
if
think
you're late-
it's. Oh, I'm really loud. Okay.
Are you
Now
still
that's
on?
no. That sound must have been really loud.
Yeah, I mean, you were probably.
Did you turn your mic down?
Mine's cranked down. Yeah, I'm at like 44.
Oh.
So if you're late, yeah, we are going to listen to the Justin calls that Broken Baker sent us right after this hearing. If you're late to the game here.
That's only because, again, I'm making an observation about what I say that they could
Is that better?
arguably help the defense or hurt the Commonwealth, but that's only because, again, when I'm weighing the potential prejudice to the defendant and the probative value, that's all I'm really getting at under 403.
So Judge, if I could just invite the court to just focus on that one bubble about the hitting in terms of the 403. And that's really all I'd be concerned about. So there's more to the story, of course.
All right, so let me just, in Commonwealth, what would you say if that was redacted? So
Am I still too
that
loud?
bubble and just,
I just think the first sentence of that would be fine to redact, but I do think that the second sentence is not about what you need anymore. We need to be the best parents possible, and I cannot do that in the house at this time. I think that's all.
so Mr. Bradl, I don't know if you've heard that. So the Commonwealth is suggesting that.
They remove the
All right,
only.
so let me just back up. So
No,
my
fuck off,
ruling
Commonwealth.
is that the probative value of these, generally speaking, of the proposed exhibit outweighs any, really almost any potential prejudice to the defendant, except that the devil is in the details as to some of the content, and that one of those items being
The one you just tried to remove.
This particular passage where Mr. A. Ellen is alleging that Ms. Fitzsimmons struck him in the face, even though she denies it right there in the response. So the Commonwealth is suggesting we simply just redact the first 2 sentences of the bubble of Mr. Elane's
Increase my volume.
text about that.
All right, I went up a little bit.
Should that be agreeable to the defense? Thank you.
Test my sound effect
And
again.
so that would, and the rest of that would come in starting with, it is not about what you need anymore.
Yes, sir.
Okay. And if you folks remind me at the time that I can tell the jury that it's common that things are redacted or struck from items just in case it's somehow visible that, in other words, if the jurors can glean that something's been removed, I'm happy at the request of either side to tell them why, which is basically I rule that it wasn't missing.
And Judge, also while we're on these, I would waive the request for impoundment.
Okay, waive the request for impoundment.
Correct.
So let's talk about impoundment. What's the Commonwealth?
Oh,
I'm just concerned about jurors just knowing.
there's no captions.
Your Honor, I do not see a good faith reason for the Commonwealth to ask for this to be impounded, given the nature of what is in the public already.
Okay, all right, so both sides say it shouldn't be impounded, so I'm gonna vacate the, and I'll do this, Mr. Brain, in an endorsement, but I'll vacate the provisional impoundment of that. What I'd like to do is this, Commonwealth, so I have two versions, one's a vertical, and one's a horizontal, is that right? Is that the way to explain it?
Yes,
So
I think the first version was too small relative to.
Yeah. So can we just give this back to you, and then you can shred it, and this will be this
Horizontal version.
landscape, right? That's the landscape? Okay.
And that's a good one to
The landscape will be the official exhibit. It will, and it can be docketed in the normal course, public, maybe.
Babe,
It's right there.
did you forget
Docketed
about
in
that?
the Public docket.
I cannot hear you at all.
Oh, I said,
But
did
keep it, but that's just me. What were you saying? Were you saying pause it?
No, I was just saying, did you know Aaron had a hearing today?
Spencer? Yes. They're setting the trial date. I'm
Oh, yeah.
waiting to hear when that, I knew. I'm anxious to know when the trial date is set.
I don't know. You still sound like you're blowing my eardrums out.
Really?
I don't know, but maybe it's also just me.
I'm really low. Here, I'll move it down a little more. I'm at like 42 now. I mean,
I was at 47, or I am at 47, so maybe I should go down lower too. All right. Crystal Justice says, you both sound good. So both sound fine.
all right, do you want to explain what's going on here, what they're trying to do?
So, and I think this is part of why the defense attorney wanted to wait till the end to make a decision about a bench or a jury trial. So right now they're going through the text messages and they're deciding, if any of them need to be deleted. I disagreed with the judge's ruling that this is somehow relevant and it speaks to her state of mind. I just don't think it is. That's why I did the whole that sound. But so now they're kind of hashing through it, but it's also good to know that when the judge is, if the judge is on this case, he thinks this is stupid bullshit and it might actually benefit the defendant. So it's little things like that you hear through this. You kind of get a double-edged sword. Like, damn, the judge found this relevant. Like he'd actually let it go in front of a jury, because judges, when they're ruling on things, when they're sitting on the bench, they can let a lot more things in. The Rule 403 analysis is like night and day, because the law just says a judge will disregard whatever, let it in and then disregard it if it doesn't have much relevance. There's no risk of prejudice because it's a judge. So right now was that what I was supposed to talk about?
Yeah, that's exactly what you're supposed to talk about, because people were asking. And I think to Allie's point where she's saying that Bradl wanted to wait to the end, maybe because he's trying to pick up every vibe the judge is putting down, right? I
Right.
mean, a bench trial is a calculated risk. You're going from 12 to 1. So, which can be a scary proposition. Now, in my estimation, in a case like this, where this case entirely lives in understanding what beyond a reasonable doubt is and how it should be applied, and it's a he said, she said case, I feel in this particular situation, the judge is going to put everything to the side in terms of emotions. I don't have to worry about that. And he's going to rule strictly on whether or not the state was able to meet its burden. And in a situation where you've got a cop who's got a motive to lie, namely his job and not having a bad shooting on his record, I think he's going to weigh things properly. And I just personally feel that this is a perfect case for a bench trial.
And Bob and I will get into this a little bit more when we get to the end and we hear what they decided. But just to answer Carol's question, now I am not a Massachusetts attorney. I did very little research on this, but I did research it. And it is my understanding in Massachusetts that you must decide before voir dire even begins, because they consider that, I guess, impanelment. So in some jurisdictions, you might even be able to decide, once you've got a jury impaneled. But from my limited research I did last week, if voir dire starts, if jury questioning starts, it's too late to waive your right to a jury trial, go bench.
And Loso for Life asked, can you appeal a bench trial?
So you absolutely can,
Yeah.
but those issues about prejudice and, if something got in the errors, it's a much different balancing act, but you absolutely can appeal to the same extent a bench trial as a jury trial. They just are going to balance prejudice differently, assuming that a judge will block out, things that they shouldn't consider, or didn't give weight to things that didn't deserve weight, and aren't going to be prejudiced if they hear something they shouldn't hear.
Yeah, that's true. That's true, DB. DB says, but he said, she said is between two cops.
Yeah, that's why I said we'll get into it. We're gonna flesh this all out, and we'll love to get all your guys' thoughts as well at the end of this when we see what they did.
Yep.
That was loud. Allie's
all right.
good.
And it can be docketed in the normal course, public made, right there, docketed to the public docket. All right. And I'll have to also endorse, I will endorse it that I'm allowing it subject to that revision, so. Just,
Yeah. That'd be nice.
And, all right, so do you folks want to take a break for a few moments? Okay, all right, we'll do that. Just,
Good thing we got some blooping time.
What?
Bloop it up.
I'm going to.
I know, I was just saying, good thing we have some blooping time.
I mean, we got a lot of blooping time because it took a long break.
Yeah.
There's only chair. Only chair. Oh, only chair. All right. So we're back.
Versus Kelsey Fitzsimmons, all
No
counsel and
spoilers.
defendant are present.
If anybody's watching somewhere else,
Thank you, Your Honor. We filed two things.
mods keep us from getting spoilers.
Of the right to a jury trial, and Attorney Coakley and Ms. Fitzsimmons are prepared to engage in a colloquy with you on that. Okay. And then the second thing we did file was a supplemental witness list that I explained.
Sounded
Thank you, Your Honor.
Sounded like you just waved.
We filed a waiver of the right to a jury trial.
Yep.
Okay.
It's a bench trial.
Bench trial. It's a bench trial. If you guys didn't catch that, it is a bench trial. It was hard to hear. They're going bench. They're waiving jury. There's no undoing waiving a jury.
Nope.
When you waive it, it's done.
Even after an appeal.
Even after appeal. That was 100% Kelsey's call. Now, obviously, Bradl and Coakley advised her, and Kelsey's smart enough to take her attorney's advice because, the defendant's not necessarily going to know which is the best way to go. So bench trial in the books. That's what's happening. No jury selection. That means this trial is going to probably last, I'm guessing, a day and a half, maybe 2 days with a bench trial.
I don't know. I can't imagine how many witnesses they have, but
right.
All right, well, let's hope we can hear stuff. Let's go.
Ooh, this is exciting.
Attorney Coakley and okay. Mr. Bradl. Thank you, Your Honor. We filed two things, Judge. We filed a waiver of the right to a jury trial, and Attorney Coakley and Ms. Fitzsimmons are prepared to engage in a colloquy with you on that. Okay. And then the second thing we did file was a supplemental witness list that I explained to my brother a little bit. Some additional names. I would say most of it is probably abundance of caution stuff that probably they won't be called. There's one name on there that did warrant some explanation to counsel for Commonwealth, which I gave them, and I don't expect it to really add much to the trial.
all right, so let's table that, but I do want to, if the Commonwealth wants
No, I just, if I may put something on the record.
Sure.
As far as the jury waiver goes.
Well, before you do that, I was going to ask, all right, so we have a waiver. I was going to ask whether the Commonwealth takes a position, so.
My only position, well, I have no reservations with your ability to be fair and impartial in this case. In an abundance of caution, I wanted to create a record. At some point, I don't think it was last hearing or one of the press conferences that the defense gave outside, a person asked about you, and Attorney Bradl told them and the world, I guess, that you and he worked together in the DA's office some time ago.
Oh shit.
And so
Oh shit. Conflict.
there's a perception out there for whatever.
Wait, what?
He's trying to raise a conflict, and that's bullshit. Judges work in state's attorney's offices with judges, with lawyers all the time. Judges work when they're not coming out of the public. I mean, then you would say you can't work on this bench because you've worked with every district attorney or whatever they are here. I don't know what the prosecutors are called here.
DAs, yeah.
An assistant district attorney in this county. So you're off. So he's trying to conflict out this judge right now, but he's tying it to a statement the defense made publicly that they have worked together in the past. So it raises the appearance of impropriety. This is why you keep your mouth shut. I don't think it's going to go far, but if you're not listening, listen now, because now that she has waived her right to a to a jury trial and has to go bench, the prosecution is trying to conflict out the judge and get a new judge. And Bob's asleep at the wheel. Hit play.
Oh, I'm tweeting. I'm
I
definitely
know,
not
but
asleep at the wheel. It's a big deal.
it's also a big, yeah.
You're exactly right. That's exactly what he's trying to do.
Whatever it is, a time ago. And so I think there's a perception out there for whatever it is that the defendant had put out there. Like I said, I have no reservations as your ability to be fair and impartial, but I think I needed to create a record about that.
Oh, that's a very good point. So, I don't, let me say this. I said before when I was joking with our media representatives, I don't pay attention to social media. I'm not on social media purposely. I don't read or listen to or watch or whatever media accounts of what happens in cases that I preside over or that I potentially could be involved in. So I know nothing about that, but I think it does make sense for me to say a couple things related to that because it strikes me that I did discuss those things with you folks, but I did it at Sidebar. All right, so I'll just state for the record that Mr. Bradl and I, all right, so we worked together, well, Mr. Bradl and I were in the same starting class of new assistant DAs in January of '95. I have Mr. Bradl, I have a picture of all of us, including Mr. Hagan, Judge Hagan, who like me back then had a lot more hair. So Mr. Bradl and I were in that class, starting class together. My memory is that I was assigned ultimately after the class. I think we met for a couple of weeks. We were a training class. I was then assigned to Roxbury District Court and Mr. Bradl to Dorchester District Court. And so that was '95. I left the DA's office in 2001, and at that time I was the chief of the domestic violence unit, which was a Superior Court unit. So, Mr. Bradl, you can correct me. I don't think that we ever worked together in the
Good
sense
try,
of
Commonwealth.
worked in the same courthouse,
Sleazy.
worked on the same trial team. I'm not sure that you and I ever even had a beer together back then.
I agree, Judge. I don't recall one, and I think that I put you kind of in the same boat as Judge Deacon down in Middlesex, where we always had a respectful cordiality at work, but, you know, nothing past that. And I've appeared in front of Judge Deacon and, you know, never been a problem. And I left the office in 06, Your Honor, so I was there for 5 more years after you. I haven't seen you in probably over a decade, you know, and I think the comment that Commonwealth counsel was referring to, I recall it as just sort of a generic comment that I thought your rulings were fair and that we appreciated the rulings, that I've known you a long time, something to that effect.
Yeah, I don't think that Mr. Robertosi was objecting. You just want to make sure that this trial, I've always strived. that
Doesn't think they
all
were
of
objecting?
Proceedings, whether it's this case or other cases, that there's a level of transparency.
We're going to go back and re-listen
And
after
I think
this
Mr. Robertosi's point is well taken. So
because I got to take a
I
post
think
out
I've
if I'm wrong.
described on the record what the nature of our relationship was. I'm not, again, I don't, I can't say that we weren't friendly, but it seemed like I was maybe you're the crew of people that you more gravitated to were from the Dorchester District Court. I was in the Roxbury District Court. But I'll also say this, is that for complete transparency, I believe I also, not believe, I know I had a murder trial years ago with Mr. Robertosi. I found Angel Morales, I don't know if you remember that, and I found working against you was you to be
Is that one of the
really
prosecutors?
good prosecutor. And
Yeah.
really
So
fair.
take that,
I
asshole.
respected you. I continue to respect you. That's what I was referring to at Sidebar.
Maybe
And
I'm
you
not
know what?
that-
I probably spent, no, I'm,
No, I was gonna say, maybe I'm not that memorable because we did 3 murders.
we did?
Yes,
Oh,
Who else?
I can't remember the name. One was with Ms. Ronan in front of Judge Lowy in Salem.
Oh, wait, all right, so I'm
And
not.
then
I'm
there was
not-
another one here.
Yeah,
I
in
can't
front of
remember
Judge
the judge.
Welch.
Right,
You know,
right.
I wasn't counting the ones where you were second seating another, you were like second seating
Right.
a more junior attorney, but I do remember one in which the 2 of you prosecutors beat me up pretty good. It was here in this courtroom.
I remember
I
that.
had made a mistake and opened the door to something, and it was Mr. Robertosi's fault, because all of a sudden that sidebar, you hadn't said 2 words during the trial, but raised the issue. But in any event, listen, I respect both of you folks. I said on the record, I don't know Ms. Coakley. I don't believe professionally. I think that you may have been the chief of a unit that in Middlesex at the same time that I was the chief of the domestic violence unit. I think we may have traveled in the same circles, though that would have been decades ago. But I don't think that you've ever appeared before me. I don't think we ever had cases against each other. Again, I respect you as much as I know you, and in any event, I think that that's full disclosure. I'll also just say, as for Dr. Zeisel, you said Dr. Zeisel is not going to give you.
Correct.
Okay. So, because I think I already mentioned it, he was someone that I used often when I was in practice. So, but it's been years since I've seen him. All right. So, is that sufficient? Did I address? All right, and the bottom line is, I am confident that I can be fair and impartial. I would not accept the waiver, frankly, if I thought that there was some risk that some favoritism would potentially come into play, or if I thought that I couldn't divorce myself from information that may not be admitted at the trial. Okay, so I'm very good at compartmentalizing. I will only consider evidence that's admitted at the trial. All right, and then we'll talk about mechanics and all that afterwards. Let's go through the colloquy. I'd like to, before we have the colloquy, can I see counsel and Ms. Fitzsimmons and Sidebar?
Okay, they're at a sidebar.
Wait, so what was it that they went to school together? What was the?
Yeah, they worked, like Bradl and him worked in the prosecutor's office back in 1996 together. You know, the judge laid it out, and like they were just making a record. Like I don't think the Commonwealth actually.
I think it was a low key request that he recuse himself. They said the appearance of impropriety. We'll listen to it again, but that's what I took from it.
Yeah, but I mean, like if you're trying to conflict a judge out, it's going to take more than like I'm trying to make a record type thing. But I mean, he definitely put it out there. He definitely planted a seed, and the judge addressed it. Let's see. Long sidebar, like a really long sidebar. Really, really long sidebar.
Of the waiver?
Yes, she is.
All right, why don't you folks, why doesn't she take the witness stand? I can pull a chair over for you, Ms. Attorney Coakley, if you'd like.
I can stand.
Oh my God. Like the sound is awful. I've never heard worse sound. What is going on? Let me see something. Never heard of such a thing.
What was it? They worked together?
Yeah, I
or they
think
went
I
to
am
school
gonna.
together?
I'm listening to Law Girls and it's really, really low. It doesn't have the. I think they're just recording from their phone mic. Your sound is good? All right. Let's go.
Please.
Mr. Simmons, could you raise your right hand? Do you solemnly swear to make true answers to such questions put by the court?
Wait, does that sound like a nightmare to you, babe?
Well, it sounds loud.
You're not hearing like huge static?
Let me hear.
Or opponent's directions to help you God.
Okay, good afternoon, you can have a seat.
Good afternoon, Your Honor.
You can put yourself right up.
I don't get it. Like my mic is like at 30.
No. I barely hear you over the sound now. So
Like it's so
It
confusing.
was the same class of ADA. See, now I have to update my thing because I think that is what they said. Who just said that? I was trying to find it.
To that mic. So as you know, I'm Jeff Karp and I'm a judge here at the Superior Court. And I understand that you'd like to give up your right to have a jury decide whether you're guilty or not guilty of the charge. I need to just ask you some questions to make sure that you understand the right that you're giving up and that you're doing it voluntarily, okay? And that you know what the consequences are. Now, so I'm going to have a lot of questions for you. If at any time you don't understand something that I say to you, it's perfectly fine to interrupt me and tell me I don't understand. If at any time you'd like to take a break and speak with Attorney Coakley, we can give you that opportunity. We're in no rush here. It's very important that you understand all that I tell you. Yeah, okay? All right, so the first thing I'd like to do is, where's the indictment, Mr. Boyne? I didn't grab that. So you understand that you're charged in a single indictment with the crime of assault by means of a dangerous weapon. Do you understand that?
Yes, Your Honor.
Okay. And do you understand that, have you discussed with your attorneys what the Commonwealth needs to prove at the trial for that charge?
Yes, Your Honor.
Okay, and do you feel as though you understand what they've told you about that?
Yes, Your Honor.
And do you understand that that charge, assault by means of a dangerous weapon, carries up to 5 years in state prison if you're convicted?
Yes.
Okay. Attorney Coakley, either you or Attorney Bradl have gone over the elements of the charge with Ms. Fitzsimmons.
Yes, Your Honor, we have.
Okay. All right. So I need to just ask you some background questions to get some background information. Some of this I already know, but I still need to I need to ask you formally. So if you could state your full name.
Kelsey Fitzsimmons.
And how old are you?
I'm 29.
What is just your month and year of birth?
11/18, November 18.
And where were you born?
Concord, Mass.
How far did you go in school?
I got my bachelor's degree and I went to half of law school.
Okay. You went to what?
Half. I did
Half of law school? That's enough. Was that enough for you?
No, I'm gonna go back.
You're thinking about going back?
I am.
And you said you got a bachelor's degree in what?
In criminal justice.
Criminal justice, and where from?
Where am I from?
No,
Oh.
where did you get the
Oh, I'm
bachelor's
sorry.
degree?
I'm nervous, I'm sorry. Fisher College in Boston.
Okay, all right, and totally understandable that you're nervous. All right, and again, some of this I know, but I have to ask, what are you can't be presently working, right? You're not working now.
No, you're
Right. And your last job was with,
patrol officer with the North Andover Police Department.
okay, and how long were you there, roughly?
About a year and a half, if you count the academy.
Okay, so you went to the police academy and
Yes.
then, okay. What else? And just normal job duties as a patrol officer in North Andover?
Respond to 911 calls, emergencies, medical emergencies, calls for service in the town.
Okay, all right. And did you take any prescription medications, over-the-counter medications, or drugs in the last 24 hours?
Yes, I have.
Okay, and what have you taken in the last 24 hours?
In the last 24 hours, I've taken fluoxetine,
Okay,
hydroxine,
okay,
and lorazepam.
all right. And do any of those medications, or have any of those medications affected your ability to understand the proceedings today here?
No, Your Honor.
All right. Did you consume any alcohol in the last 24 hours?
No, Your Honor.
And have you ever been treated for any mental health condition?
Yeah.
Okay. Do you feel as though that you're suffering from any mental health condition today? In other words, that like right now as we're going through this, that you're feeling
Symptoms.
some effect of any mental health condition?
No.
And do you feel as though your mind is clear today?
Yes, Your Honor.
And have you understood all that I've discussed in open court with the attorneys about, up to this point, about even like the motion to admit the text messages? Have you understood all of that?
Yes, Your Honor.
Okay. So I'm just going to go over your constitutional rights. So you have a constitutional right to one trial of the charge. And you have the right to choose whether to have a trial before a jury or a judge. At a jury trial, the jury decides whether you are guilty or not guilty of the charge. And the judge's job during a jury trial is to rule on legal issues that arise during the trial, to instruct the jury on the law of the case, in other words, what the Commonwealth has to prove, and to impose a sentence if the jury were to find you guilty. So that would be the judge's job during a jury trial. But the jury would decide whether or not the Commonwealth proved that you were or are guilty beyond a reasonable doubt. All right, you understand that?
Yes, Your Honor.
And at a jury trial, you have the right to a trial here with 12 jurors. These are people selected from the community. You'd have the right to participate in selecting the jurors, and you could not be found guilty at the jury trial unless the Commonwealth convinces all 12 of those jurors that you are guilty beyond a reasonable doubt. So do you understand all of your rights and how a jury trial works?
Yes, Your Honor.
All right. And also, you could choose to have a trial by a judge instead of a jury. And in such case, the judge cannot find you guilty unless the Commonwealth convinces the judge that you are guilty of the charge beyond a reasonable doubt. Do you understand your right to a judge trial?
Yes, Your Honor.
You understand that by waiving your right to a jury trial, the judge will be me. I will be deciding whether
There answers that
Commonwealth
question,
has
everybody.
proven the charges. Do you understand that?
Yes, Your Honor.
Babe.
And you understand that by waiving or giving up your right to a trial by a jury, that I just already told you that. So do you generally understand the difference between a judge trial and a jury trial?
I do.
Okay. And do you have any questions at all about those?
I just wanted to say for anybody who was still wondering, and maybe, sorry, you want to tweet it out there for the world, babe, but for anyone who was concerned that the judge might change, he just said in her waiving her right to a jury trial, I will be the judge here. You have a bench trial will be a judge, and I will be that judge, and I will make that decision. So anyone who was worried about that, put it to rest. This
Yeah,
is
it
our
was never
trial judge.
happening. It
I
was
know,
never
but
happening.
people were worried. So
I know. I already, that was never happening.
no.
You and I knew that.
Yes.
The difference between those two types of trial?
I do not.
Now, I'll just hand you this. And I'm showing you a form called the Defendant's Waiver of Jury Trial and Consent to Trial by a Judge. Did you read that form?
I did.
Did you discuss it with counsel or the attorneys?
I did.
All right. And did you sign that form?
I did sign it.
And do you understand that the form says in writing what you and I have been talking about thus far about giving up your constitutional right to a trial by a jury?
Yes.
Okay, did you sign that form voluntarily?
Yes, I did.
And by signing the form, are you saying in writing that you know about and understand your right to a jury trial, which is explained on the form, and that you voluntarily give up that right?
Yes.
And do you now willingly and voluntarily waive your right to have a jury decide your case instead to choose? You think that I have never done this before. Maybe I'm the one that's nervous.
I'm nervous.
Let me start over again. Do you now willingly and voluntarily waive your right to have a jury decide your case and instead choose to have a judge, that being me, decide if you're guilty or not?
Yes.
Okay. And do you understand that your waiver of your right to have a jury decide your case is final, and you cannot change your mind and ever ask for a jury trial again in this matter? Do you understand that?
Yes.
Has anyone threatened you or forced you in any way to waive your right to a jury trial?
No.
Has anyone promised you anything in return for your decision to waive your right to have a jury decide the case?
No.
Have you had enough time to fully discuss your right to a jury trial and the difference between a jury trial and a judge trial with your attorneys?
Yes.
Do you feel as though your attorneys have acted in your best interest and that they have fully and adequately explained your right to a jury trial and the difference between the two types of trials?
Yes, Your Honor.
Have you been confused by anything I've said thus far during this colloquy?
No.
So as I understand it, then you're waiving your right to have a jury decide your case, and you're choosing to have me, a judge, decide whether or not you're guilty because you want to and because you believe it's in your best interest to do so. Is that correct?
Yes, Your Honor.
All right. And the defense, any additional questions that I should pose? Commonwealth?
No, thank you.
None? Okay. All right. Does the defense or the Commonwealth know of any reason I should not accept the waiver?
No.
No, Your Honor. Okay. All right. You may step down. Thank you very much.
Thank you, Your Honor.
All right. I'm going to make the following findings. Yeah. No. Mr. Royan can take that. Thank you.
So loud. I think you overlooked it.
So I'll make the following findings. I find that the defendant, while she is presently or has taken medication, prescription medication in the last 24 hours, I find that that medication has not affected her ability to understand and participate fully today. I also find that although the defendant, Ms. Fitzsimmons, has reported that, or at least, I don't know if she reported it, but I do know that at least in the past, she suffered from mental health conditions, that perhaps some of that medication is related to that. I do find that any mental health condition that Ms. Fitzsimmons may have had or has not affected her ability to understand and participate fully in the proceedings here today. I further find that Ms. Fitzsimmons understands the nature of the charge against her and the consequences of waiving her right to a jury trial. I find that the decision to, I find that Ms. Fitzsimmons' decision to waive her right to a jury trial is made with the advice of competent counsel. And finally, I find that the defendant's waiver of her right to a jury trial has been made knowingly, willingly, intelligently, and voluntarily, and with the full knowledge and understanding of its consequences. And accordingly, I accept Ms. Fitzsimmons' waiver of her right to a jury trial.
That's official right there. So the judge gave a very lengthy colloquy. And the reason that the judge did that, put her on the stand, put her under oath, asked all those questions, is because a jury trial, the right to a jury trial, is an incredibly important constitutional right, and only the defendant can waive it. So the judge asked all those questions so that somewhere down the road, God forbid that Kelsey were convicted and she wanted to appeal it, and she turned around and was trying to say, oh, well, I didn't understand, I didn't know what it meant. That's a no-go. The judge asked all those questions to make a very clear record that she knowingly, voluntarily waived jury, that she understood what she was doing, she understood what it meant, and now the judge has accepted the waiver. So that step still had to take place. So it's in the books, it's in stone, jury waiver in place. Judge Karp, as Ali said, is 100% sitting on this as the decider of fact, the trier of fact. That's the difference. Bench trial, the judge is the trier of fact, meaning that the judge decides whether she's guilty or not guilty, as opposed to a jury where they're typically the trier of fact. So big day, big day.
All right. With that in mind, so we'll.
Now it got loud again, babe.
Anything you folks want to?
What?
Whew, it got really loud again. You had it not too boosted, and then maybe it's not you, and it's what's
I
going
didn't
on.
touch anything like when I restarted it. So it's just the court volume just stinks. There's not much I can do about it.
Go over, but I anticipate we'll just start on Monday morning. Are you prepared to? Because maybe you're not.
Because you thought we'd be in
given
Quadir.
what I had said that-
Sure, I hope to be. I mean, that wasn't the plan for all our witnesses, but we'll reach out today and make sure,
Okay.
or ensure everybody that we can have is available Monday.
Okay. All right. And so let me say this. I realize that from both sides' perspective that, trying a case, whether it's jury or not, is like trying to, it's difficult herding all your witnesses together. I usually try to make a joke about it. It's like herding fish or something, but Mr. Kubatosi's heard that probably 300 times. But in all seriousness, we will, Mr. Roy, we're going to go full days. And to the extent that you run out of witnesses on a day, that's just life, that's fine. Do you expect now with this new, let me ask, with the new kind of schedule where the actual evidence in trial is going to start earlier, do you expect any witness availability issues?
Well, everybody was free for the week, so no. I mean, I don't anticipate whether somebody is available Monday in particular.
Okay.
We'll find out.
All right. So it is my anticipation that however we proceed, that the trial will be over by Friday. Is that a good, fair
5-day bench? Wow.
Fair belief that I hold, I guess?
Yes. So,
Okay. And, okay, so we'll just start up on Monday morning, all right? I will see you folks there.
Yeah, I'm sorry, I just wanted to point up something for you that you were talking earlier about jury instructions and instructions that you would take into account yourself. And there's one slight, maybe a curveball. There's a code of Massachusetts regulations. I just want to give you the citation. It's 555 CMR 6.05 parentheses 3, close parentheses.
All right, so let me say this, I don't know exactly what you're
I don't know what that
referring
is.
to, but maybe it makes sense for me to just explain. So what I will ask is that you folks
missed it.
submit, they can be in the form of jury instructions, but just, yeah, instructions that I will use when I deliver as to the law of assault by means of a dangerous weapon. So whatever it is that you're referring to, Mr. Brady, you should just put in that document again, whether it's however you want to title it is fine, but.
It's from the post-commission regulations, Judge, and it's a CMR that states that an officer is not permitted to use deadly force to someone who is a danger only to themselves. And that's really the central issue of the case.
Right, but again, without having it in front of me, what does that have to do with whether the Commonwealth will be able to prove that the allegation is that Ms. Fitzsimmons committed the assault.
Right, I don't get it either.
Assault by means of a dangerous weapon, so I'm not following.
I think it has sort of a general import where if the court has a reasonable doubt as to whether or not Ms. Fitzsimmons was engaging in
Should have raised this before.
conduct that was harmful only to herself, it does not, by law, excuse the
How's that relevant?
Officer Noonan shooting her.
Frankly,
I'll spell it out.
I don't understand, but
I'll spell it out. It's
so let me just hold on one second, Mr. Brady. What I expect is that perhaps at the end of the evidence and even before closings, we'll have a charge conference. We'll treat it just like we would in a jury trial, and you folks can make your pitch on the law. But I will want some submissions on the law that I should be. Again, as it relates to the charge and the elements and things of that nature, if there's some defense that you're asserting related to that, you can, perhaps that would be a mechanism for raising that. All right, but right now I don't understand it, and I'm not sure that I need to at this point.
It was kind of silly.
And anything else?
Your Honor, do you start at 9 a.m.?
Yes, I'd like to. We do our best to start at 9. Mr. Wayne and I are always ready. But
I know Mr. Wayne is up early.
But Mr. Wayne and I are seem to be the only ones that are ready at 9. But
And just folks, 9 to 4 is a full day for the court. I'm just,
right.
Okay, thank you.
It is. And like I say, if you folks can disclose to one another what witnesses you think you're going to be calling on a given day, and that would be.
And with your permission, I think we should be able to pre-mark a number of exhibits.
Yes.
Okay.
So you'll work that out with Mr. Wayne. That would be great. Also, if we need to take a defense witness out of order, I certainly would hear the Commonwealth if there's opposition to that, but even for a jury trial, I typically would allow that. Again, if it's a scheduling related matter, not a strategy related decision, but if there's some scheduling conflict that will help see. All right, so we will see you folks Monday morning. Thank you.
Thank you.
Thank you, Your Honor.
All rise, please.
So are we eavesdropping for a minute? Is that what we're doing? All right. So Heather asks a really good question, and it's something I want everyone to think about. In a bench trial, is the defendant more likely to take the stand? And I'd say yes and no. And the reason I say yes is just for a small reason, because there's so much of it that goes to the way a jury will perceive you, your tone, your tenor. Like, what if they just don't like you? And what if they think, some people think you're, like, if you think about it from the Karen Reed perspective, well, maybe some people think you're a snob, some people think you're a bitch. Those issues you don't have to worry about with a jury, with a bench trial. You also don't have to be too concerned with the judge, over putting too much weight on your background, your criminal history. But there's still a lot of other concerns that are the same no matter what. I don't know. What do you think, babe?
Yeah, I think in this particular situation, it matters not, because I think she has to testify. This is a he said, she said. But in general, I would agree. A lot of the things that you concern yourself with respect to how the defendant presents themselves to 12 individuals doesn't exist with the bench trial. I think the judge will just take the testimony at face value without adding all those other elements that you articulated into his mindset in terms of what he's thinking. He's just going to listen to the facts as they're presented through the testimony and go on that without any of the extraneous stuff being involved, which is always a concern. We talk about it all the time here with respect to one of the primary reasons you don't put a defendant on the stand. I mean, you make one slip up on the stand as a defendant in terms of something that could be misconstrued in terms of how you said it. It's really scary with the jury, whereas with the judge, and in that knowledge of the law, the understanding of the rules of evidence, and just the fact that he's an attorney prior to becoming a judge, I think all weigh in favor of, in this case in particular, she's got to take the stand. I don't see any way around the fact that she has to take the stand. Otherwise, you're just having the cop up there giving his side of it. And if it goes unchecked, the judge doesn't have anything to balance against.
Right.
I mean,
yes, she would have to take the stand.
Yeah,
I agree. In this situation, can't just infer it without any sort of evidence of her intent. She's the only one that can speak to that. So we also had, and ain't so plain Jane at the end. We will get to Afro Man. I definitely want to kind of touch on that real quick. But we also had Eroy say, what would happen if there was a bench trial and she was found guilty? Would she be able to appeal? Is it the same as a jury trial? I've only watched jury trials. And we touched on this earlier because someone else had asked the question, and sorry, I didn't notice the sticker, the super, at the time when I put the other comment up. But yes, you have the same rights to appeal on a bench trial as you do a jury trial. But like I said, that kind of, when it comes to prejudice and balancing some errors and whether it's a harmless error, the harmless error test when you're dealing with a bench trial is much, much more. It takes a lot more to find harm. The judge would have to say something in his ruling or some kind of comment or something that spoke to the point that this judge actually considered something that he shouldn't have, where usually they're going to say, well, the judge heard that, yeah, but he didn't consider it. Judges can disregard things.
Carlene, you don't need to think anymore. Kelsey waived jury today. It is 100% a bench trial. If you're late to the show, that all just happened. She went through, the judge gave her a colloquy, explained what the rights are, asked her a series of questions to make sure that she voluntarily and knowingly waived her right to a jury trial, asked about whether or not she was taking any drugs or was on alcohol, anything that would affect her ability to make a knowing
that's
voluntary decision. So that's in the books.
So Soap API says the DA is really digging deep today to give us the most smooth brain slop of their careers. I mean, that I did kind of want to go back because I think that was, I don't even know how low.
I don't even want to hear like the sound was so bad. Like
I thought that the prosecution, although the judge was like, oh, I don't think they're really objecting. I think they were absolutely suggesting, should we have a discussion about whether you should recuse yourself because you guys knew each other in your DA class and the defense told the public that you guys, whatever.
I mean, at that point, the waiver wasn't final anyway.
It was signed, and
yeah, but the judge hadn't accepted it yet.
That's true.
So I mean, it is what it is. All right. So what I want to do now. So again, if you're late to the game, Kelsey has waived jury, meaning she's going to have a bench trial. Look, it's always a risk. It's always a risk.
Can you undo? Oh no, we need the boost on for these recordings anyway. Never mind.
Wait, am I too low now?
Don't change it. No, you're loud, but I forgot we still have the boost on for the Baker.
I don't have the boost on. I'm not like the boost is only on when I have a stream on.
I don't know.
Like, this should be like normal. I don't know.
How do we sound, people? How do we sound?
Oh, the sound stuff just drives me nuts.
Maybe I have my.
And I hate when you ask because it's like always the entire gamut. You sound great. Bob's loud. Bob's low. Allie's loud. It's like we never get an actual answer. We never get an actual answer because everybody's sound is different. Everybody's sound level, what they're listening on. Do they have headphones on? All that stuff. All right. So we're going to pivot. Obviously staying on Kelsey's case, but Broken Baker had sent me all of the phone calls to the PD regarding Kelsey Fitzsimmons. I have not listened to them at all. It looks like there's 1, 2, 3, 4, 5, 6, 7, 8. Looks like they run about maybe 20, 25 minutes in total. I hope the sound is good.
So what are these, by the way? Where'd they come
These are
from?
phone calls from Justin to the PD.
How did they get released?
I don't know. There were transcripts of them out there. I didn't ask questions. I feel pretty secure they're not AI. I think they're legit.
Well,
I think they're legit. All right. So let me see. All right, you guys are going to have to, we should be able to hear them. All right. I'm going to start in order. I don't know if they're in order. I'm going to start them. I'm going to play them in the order that they were sent. All right. So you guys let me know in chat what you can and can't hear. And
if
I don't know.
If anyone has the transcripts, let us know in chat and send them to us.
Yeah.
North Andover Police and Fire, this is recorded.
This is Justin O'Lan. I need to go OIC.
I'm sorry, who is this? Who is this?
Can you guys hear that? You hearing it, babe? Okay. The OIC is the officer in charge.
Hello?
There is an echo, but we can't change that. Unless Bob has it playing on a different screen too. What's that, hold music? What's happening?
I'm going to mute my mic. Maybe that's where the echo is coming from.
It stopped. It was in the beginning. It was there.
Okay, so right, because like people chat late, so I can't tell if they're still hearing it. So I think if I mute my mic, it gets rid of the echo. I think it was picking it up on my mic, and that's why you're hearing the echo, I think.
I take it you can't like fast forward. Just, yeah, let it play. Wait, did it just end or you ended it? Okay. All right, that was the first one.
Chevy though.
North Andover Police and Fire, lines recorded.
This is Justin again. Can you please bring the OIC?
Yes, sir. Just give me a moment, please. North Andover Police and Fire, your call is being recorded. Hello? Hello? Police Department. Hello? Good morning, this is Lieutenant Whitaker.
Lieutenant Whitaker, this is Justin Alain. I'm at 125 Phillips Brooks right now, retrieving my belongings.
Okay. Hello? Hello, Justin? Justin, are you still there? Hello, Justin?
Say that again, sir.
Justin, are you still there?
I'm still there. It connected to my truck for some reason.
Oh, I thought it was my phone was messing up or something. Yeah,
No,
so you said that you were over on Phyllis Brooks gathering some belongings?
Yep. Grabbed my belongings. The alarm did go off. It had changed the locks. The alarm did go off. Her dad has he set the full system up. He has everything. He's going to know the alarms went off, and I have no doubt in my mind he's going to be driving down from New Hampshire to show up here.
Okay. Whereabouts from New Hampshire would he be coming from?
He's up in the not the Rochester. I forget exactly what town he's in. He's probably about 40 minutes away, 30 minutes away. I don't know if he's coming, but I have no doubt in my mind that man is going to come down with a vengeance.
All right, I paused it. Tracy.
Whoa, you're loud.
What?
Just let him play.
I think you have your volume cranked, dude.
Well, I do to hear it good, and then you come in loud. So
I'm at like 60 degree, like 60.
All right, so go on. What were you going to say?
So Tracy's saying we're listening out of, how am I supposed to know what the order is? I have no way to know what the order is. Like, I'd love to play them in order. I have no idea. All I have, Baker sent me 9 different, or 1, 2, 3, 4, 5, 7 different phone calls. Yeah, I mean,
unless they're not labeled in any way, right?
They're not you're looking at them right up here. They are not labeled in any way, and I'm just playing them in the order that they were sent. So, whatever he attached.
Okay. I mean, do you think that
I called 2 times. My family should have never been in this position. I called 2 times, once yesterday, once today, and I'm asking for a detail down here for 2 hours. If that's something that you guys cannot do, I will gladly escalate the situation. This is ridiculous.
What do you mean by escalate the situation?
I will go to the media. I will do whatever I have to do to ensure my family's safety, my brother's safety here, and 2 firefighters that are here. If his family comes down, they are absolutely going to be doing something.
Okay.
And if you're saying there's no resources for this, it's insane.
If you need a detail, I can put a detail out.
I will not be paying for a detail given the circumstances of this. You can bring this to the chief. Please bring it to someone, because I am not paying a cent for this. This is ridiculous. Given the circumstances and the escalation of this situation, providing a detail and having it be your guys' idea is unbelievable.
We can provide a detail, but you're going to be charged for it.
I will not be charged for that. You know what? I am glad this is the 3rd time this is happening, because when something does happen at this location, it is going to be all on that department. Once again, this is unbelievable.
Justin, when he gets there, just call us and we'll send an officer over there to keep the peace.
That's not how it's going to go down, but thank you for your time.
All right, wait, babe. People are suggesting maybe start at the other end, just see what the last one and go that way.
Okay. Well, that was him being a whiny little shithead.
Yeah.
What an entitled douchebag.
That's what Julie says.
Okay, so I'm going to start at the 507 call and then work my way back to where we just went. You guys let us know. I'll happily play them in whatever order if you're knowing what the order is.
Okay, no, please invite. Turn recorded.
Hey, this is Justin Land, off-duty firefighter. Can I speak to your OIC?
Hold on, sir.
He's asking for the officer in charge.
Lieutenant Solis, can I help you?
Hi, this is Justin Land. I'm going to 125 Phillips Brooks to retrieve all of my belongings today with other members of the fire department. I had spoken to Sergeant Gerke yesterday about what would happen if she said I had full authorization to retrieve all my belongings, and if her family shows up to call for a police officer. Given the intense nature of what has happened in that house and what her family has already been trying to do, I need to request a police officer there at 9:30 when I show up.
Okay.
We're going to be there for 2 hours, and given the potential and the intense nature of what happened there, I don't know what has happened. I don't know what they're going to do, and I'm going to have to request that a police officer is there.
Okay. Yeah, we have. Can you hold on 1 second?
Yes, sir.
Thank you.
Going with other members of the fire department for 2 hours. Yes, because I need to steal some shit. I need to take any evidence that's going to hurt me. I need to remove any reference of her being a good mother and partner.
Justin?
Yes.
Yeah, I'm told that the plan is if anybody does show up to give us a call, we'll be there immediately. We're very limited today on staff, but if there's any issue at all, we'll be there momentarily.
All right, I'm going to have it noted that if something does happen, I requested 2 times for a police officer to be there from the beginning. I want that noted because I will escalate this further because this is not right given the situation that occurred in that house and the potential for something else to happen. My family should have never been in that position in the first place. Now I'm requesting something that is shit that should be placed there, and you're telling me no several times. That right there is not right.
Justin, it's Katie. We spoke yesterday.
We did speak yesterday. We did speak yesterday. Given the intense nature of this situation and what could occur, I'm going to be there for 2 to 3 hours. I know what her father's capable of. I know what could happen.
But
media are there. I'm just telling you.
I understand the stressful situation, but what we spoke to yesterday was that We weren't gonna prevent you from going in the house, but if something happened, you could call us right away and we'd be there and just to, that was what we
Okay,
spoke.
no, we did speak about that, and after thinking about it again, I wanted to make my concerns noted 2 times. So if something does happen, if something does occur, this will be noted, and I have no problem escalating it further. I appreciate your time. Thank you, and have a good
What
day.
time are you heading over there?
I will be there at 9:30 with 5 or 6 other men. It's going to be a couple hours.
All right, well, there was no like formal request at a certain time, Justin, and I understand.
I understand that. I went through Crystal as well. I asked Crystal. Crystal said she would ask as well. That I never coming back to me. This formal request. I called yesterday. You gave me this information. I'm calling again this morning, and I'm telling you that. You guys do last minute details every single day. This is a last minute detail. Yesterday would have been a detail that was not last minute.
Would you like a detail?
I am not paying for a detail.
Okay, all right,
My family should have never been in that situation. My child and myself should have never happened. I will absolutely escalate whatever I have to do. If I'm saying that I don't feel comfortable and I don't want to put my brother again, my friends into a situation where something could occur, or if you knew what happened, I don't know what her family would be capable of at this point. They've already filed negligence against me as the father when there has been nothing. I don't know what they're going to do. I don't know what they would be capable of. But if you want to wait and find out, that is on you. And I am glad this is a recorded line.
Okay.
So I will be
North
there at
Andover Police and Fire
9:30. If you
calls
do not
being
have
recorded.
someone there,
Hey, this is Justin again. Just calling Lieutenant Whitaker
back.
back. I just missed his call, unfortunately.
Yeah, Justin, it's me.
Oh, okay. How you doing, sir? I had a
Good.
couple quick questions for you again.
Yeah.
So she's messaging me telling me that she's planning on taking the baby up to the land in New Hampshire. Do I have any rights to make sure that she does not leave with that child?
At this point, I don't think we do. I've spoken to my superior.
Yeah.
Filled him in on everything that we talked about, and we don't really have the right to deny her child.
Do I have any rights as the father to obtain my child since she's had him for several nights now? Do I have any right to?
Wow.
This is the custody. We're both parents here. It's almost my turn to have the kid for the night, so I can know that he's safe and I can go file these after.
Through the police department, no, we don't have that ability. The only way that you would be able to do that if you spoke directly to her and said, you know, I'd like some time with the baby, and if she agrees to that, great. But it sounds like she's probably not gonna be. Yeah.
I have my sister who's
Hey
had a
there.
quick question for you as well.
Yeah. I've seen a lot of this, and so I'm on the page of we need to get the baby out of her hands like now, or something
Wow.
really bad could happen. And I know you guys have talked a bit about this, but I am just wondering, is there any difference if she were to try to take the baby out of the state? Does that go against anything? Because that's what she's threatening with. Does the state matter at all? The state line?
No.
It really doesn't. It's her child.
It doesn't.
You know.
Okay.
Yeah.
One other question for you, because I think, we're talking about going to the courthouse. How do we, and especially because she is a police officer in this town and everyone talks, and I'm just wondering if we go file this, how do we, because if she finds out that this is filed before it's being addressed, it's going to end really horribly. So how do we actually ensure, and I guess, do you know anything about that process? Would a police officer come with us or with Justin to the house to get the baby? If this is assuming the custody was ordered, that the restraining order and the custody were ordered, what does that look like? Because we're very worried she'd find out before it could actually take place.
Yeah. So if that's the case, then the way, if an order is granted, they will then email a copy of the order to us for service. So we would serve it and then enforce it. So it would be like, here's your restraining order. Per the order, custody of the child is awarded to Justin, in which case we would have to make arrangements, for him to come take the child.
Okay, so he would not be there when you're presenting that. I mean, this might be an obvious question, I guess, because if he has the restraining order, he shouldn't be there. Is that
Probably
correct, that you
not.
guys-
I mean, we should probably take care of that. It's okay if he wants to be close by, like,
Yeah.
in order to take custody of the child quickly.
Yeah, right.
You know, he could come if he's in town. You know, we could then reach out to him and say, okay, she's been served. You can come pick up the child now.
Okay, one, just to, I guess, make sure that, because I know you guys will get notified if there is an emergency order, but
Just for clarification purposes, is this his mother?
No, that's his sister.
So the sister, and so what they're talking about, this gives us the background.
Right.
This gives us the background as to why the restraining order was filed. It was an absolute move. Like we all knew it was a move. But this proves that it was just a move. I mean, you see it all the time in these types of cases. This is exactly what's done. This is what I'm always talking about. These statutes are not supposed to be used as swords. And that's exactly what he's doing. He's doing it to position himself, number one, to get his hands on the baby, and number two, for the future custody battle. So like it served two purposes for him, both in which are not what the legislative intent of the statute is. Shitty, super shitty. So well, let me ask you this. DB keeps asking whether or not these would be admissible at trial.
I don't think so.
I mean, I could see some, and when I
state
know
opened
that's
the door-
frustrating for everybody out there, like, you know, because everybody, in terms of like listening to this, it gives us background, it gives us context. But in terms of the case, and we're talking about the criminal case, and whether or not the cop was justified or truly felt that his life was in danger, is it relevant to that? I mean, it's like maybe if they were to show that this cop kind of had an understanding, but I mean, he's just doing his job going in to serve the thing. You know what I mean? It's like I'm hard pressed to see the relevance as to the criminal case, as to the charges.
Right.
As much as I think it, you know, and it's frustrating. It's frustrating for people because we all know that, you know, in the wider scope of things, obviously it's relevant.
Right.
Obviously, in the family case, when it gets to that point, this is
definitely
highly relevant.
Right.
Huge. It's like smoking gun evidence, in my estimation, that this was not based on any kind of actual fear. This was just a legal maneuver. But in terms of the criminal case, I don't know. I don't think I can't see any relevance to it.
If
Go ahead, babe.
Oh, nothing. I was just going to say, I thought if he took the stand, I thought all of this stuff should be relevant because it goes to his bias and prejudice against her. It demonstrates he is prejudiced against her, that he will do anything to hurt her, you know, stop at nothing. The judge wasn't feeling that. But now that it's switched from a bench to a jury, actually, that means kind of more stuff will get in. He'll weigh in the favor of letting evidence come in because there's not the prejudice level is low. So when you're weighing, you know, probative versus prejudice, the prejudice is much, much less when you're dealing with a bench trial. But I don't think that they're
Yeah,
gonna sound like
think-
they might not put him on anymore.
Well, I think this kind of like encapsulates what I was talking about. Like, I think that's the feeling that Amber said it was underhanded and all of this is his fault. True. However, the moment in time that is in question here, and that's that few seconds up in the bedroom when this shot occurs, is all that matters in this trial. Like
Right.
how the cop ended up there.
Right.
Isn't
Why he was
really
there,
relevant.
how unfair it was that he was there, that
Right.
he should have never been there. None of that comes into play.
Right. But again, for the thing that matters to Kelsey, probably more than the criminal trial, is her getting her kid back. This is all coming in. Well, especially that last voicemail, because it's very, very important. Oh, and I also wanted to mention I'm really excited. Former judge, retired judge Carol Erskine is going to be joining Allie and I during the Kelsey Fitzsimmons trial. She's teaching some classes, so she'll probably bounce in and bounce out. If you don't know about Judge Erskine, she's an incredible advocate for children in Massachusetts. She was on the bench for a long time. She's an amazing, amazing person. I've seen her on a couple of different shows. Her and I chat privately, and
So
I
tell
just
your
know that,
friends, tell your neighbors,
yeah,
tell everyone. If you watch it here with us, you're getting in Massachusetts input from a Massachusetts judge live during trial.
indeed, indeed. All right, let's keep going with this call. They still seem out of order, but I mean, it is what it is.
Like, I mean, she's an officer, of course. What does she have access to see? I'm just like, is there a way to flag this directly to, you know, the trusted?
No, when it
I don't
gets
know,
sent,
friend?
it gets sent to the officer in charge. So
Okay.
nobody sees that except the officer in
Okay.
charge and anyone else who has access to that email, which she does not.
Okay, so that's reassuring. So I'm just trying to make sure there's no chance she could find out before this happens.
Did she catch wind at while she was at the police station of anything occurring? Like,
Nope.
no, okay.
Nope. I didn't want to tip her off and give her the opportunity to do anything rash.
Okay, thank you. All right, officer, I appreciate your time. Thank you.
Very good. Thank you.
Take care.
Bye-bye.
North Andover Police and Fire being recorded.
Hi, I'm looking to speak with Lieutenant Whitaker.
He is actually tied up at the moment. Can I ask your name?
I had actually just spoken with him. This is Justin Alayan. I had just got off a phone call with him.
Hold on 1 second here.
Okay.
Two things. Number one, why aren't you dancing with me? And number two, I was not aware that Baker was dancing. Obviously, I've seen your chat. I dance to hold music because I love it. It's glorious.
Was that the end of that call?
No, I paused it because I wanted
Oh,
to tell you guys
thanks.
how much I
We're-
actually love dancing.
We're glad to
hold
hear it.
music. Yeah. All right. Thanks. Appreciate that. Whoa. 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 Are you muting me?
I muted you because I thought you were about to hit play.
Now I'm muting you. How you like them apple?
Hi, sir. He'll be giving you a call right back.
All right, thank you very much.
All right, bye. Northern Police and Fire, this call is recorded.
Hi, this is Justin Alayan. I'm on the North Andover Fire Department. I am off duty right now. I do need to speak with the OIC.
Yes, sir. Hold on 1 second, please.
I think we might have heard this one, but well, let's see. No? Again, asking for the officer in charge, the OIC. I'm not dancing.
Hey, is this Justin?
Yes, this
Hey,
is.
it's Katie. How are you? I mean, that's a silly question, but I digress. I do care.
No, I'm doing as well
Thinking
as I
about
can be
you
right now.
guys.
And
Yeah. So what can I do for you,
Katie's
Justin?
good.
What's that?
I needed to discuss my options of retrieving all of my belongings from Phillips Brooks.
Oh, gotcha. I gotcha. Well, it's your house, so
Is it?
Okay, so clearly we're out of order. So the call that we heard, the 4-minute and 18-second call, was obviously pre-RO. Okay, now this is post-RO. In the first 3 or 4 that we listened to were all him trying to go get into the house.
Right. And this is the one that they mentioned in the last hearing, not obviously today's, but the hearing that we covered days ago, where Justin is misleading the officers into thinking that it's his house because he's trying to say I had every right to go in. So this is the call he's relying on, is saying he had every right to go in. He was authorized to go in, and the police gave him the okay to go in. So go ahead, babe.
Yeah, and misstated the fact that it's your house too. Oh, really? It's news to us. It's not his house.
I'm assuming that you can make whatever arrangements if you just want us to because let's just say if this were, a scenario we deal with in any other case,
Yeah. Any other?
with restraining orders, there's nothing barring you from returning to your own property except for your own safety. So I can't, we don't have any jurisdiction, and we don't even navigate about mutual property. So when we get restraining orders,
Mutual.
people have to, commonly the defendant would ask to, it's different in this case because you may be in stow, from what I understand. But any property that's in there is between you, Kelsey, and civil courts. It doesn't have anything to do with us. We have no jurisdiction to say what can't be removed, what can be removed.
So am I able to go to the house with
good point.
a bunch of fire buddies and remove my belongings?
Yes. We have no jurisdiction on that. I don't, are you in communication with her family and things like how?
No, I am in no communication with her family whatsoever.
Yeah. Do you know if they're at the house at all? That would be my only thing. If you wanted to go, if you feel like they're there, and I mean, it's your house.
Throw up Lucifer's comment again.
We're going to talk about it afterwards for sure.
Yeah, because it's interesting, because I'm trying to remember, was the one kind of blast email that this woman, Katie, sent out regarding the service of the order?
Yeah, I don't know.
Because if that's the case, then I think Lucifer has a pretty good point here.
Well, let's finish it and we'll discuss it.
Okay.
So truly, you can go in there anytime you please. And let's just say hypothetically they were there and they get all bent out of shape about that. What you could do is just call us for us to explain that to them.
So my only concern would be I know they're blaming me for a lot of this situation.
Yeah, I get it.
They are there. For the potential retaliation or any of the sort.
Yeah. So you can play it however you want it to play it. I'm going to leave that up to you. One option would be to shoot them a text or anything, and just so you know, I'm going back to the house to pick up some belongings.
They would
say no, absolutely not.
I'm pretty sure they would show up.
Yeah. Okay. So what you may want to do is just go do what you got to do. I can't keep you from there, nor would I want to. It's your house as well. It's your property.
So it's technically the deed is in her name.
Sure. But you're
obviously a resident of that house.
Yes, you have legal standing in there as far as the civil courts are concerned. You have keys. You have access. I know you live there. We know you live there. We're not going to stand in your way from collecting your property.
Hey,
if
rewind.
You go and do your thing. And just, if you get there and someone's there,
Pause it a sec.
and before you even go into the house, you know, you could call us and, you know, meet us over at the school parking lot area.
I wanted to hear that again. Did she say, we know you live there, or we know you lived there? So you guys help me out and chat what you hear as well.
You want it to play it, I'm going to leave that up to you. One option would be to shoot them a text or anything, and like, just so you know, I'm going back to the house to pick up some belongings.
They would
Say no, absolutely not.
I'm pretty sure they would show up.
Yeah. Okay. So what you may want to do is just go do what you got to do. I can't keep you from there, nor would I want to. It's your house as well. It's your property.
So it's technically the deed is in her name.
Sure. Sure. But you're like
obviously a resident of that house.
Yes, you have legal standing in there as far as the civil courts are concerned. You have keys, you have access. I know you live there. We know you live there. We're not going to see
Babe.
Well,
You unmuted right when she said it. What I was waiting to hear.
all right, I'll rewind it a second. So, but the takeaway from this is never ever take legal advice from a cop.
Right.
This woman has no idea what she's talking about.
None.
There's a restraining order in place. He's not allowed in that house any more than she's allowed in his house. There's a stay away aspect to it. Now, if he wanted to go retrieve his property, typically what they do here in Illinois is it's indicated in there. It's like it's in the pro forma boilerplate order.
Yeah, but typically, babe, it's when the person that the order is against needs to get in the house to get something. They let them return with cops to get something. So technically, I don't know if it would mention it for him. And technically, he is not ordered to stay away from her. She's ordered to stay away from him. But I do think like he's not a resident when he moved out days before, and he put
But see, you can't, like, we don't know what happened in that hearing. Like, I am sure, because typically what happens is you and I have seen it happen, wherein the person who goes in and gets the RO, who is residing in that place, typically tries to go in and say, I live there. And what they do is we've seen it where people have been removed out of their own house that they are the owner of. And the person that went in on the order that has no vested interest in the property is given possession of that property.
Right. And he's specifically right, as Dusty Rose pointed out. My understanding, and Dusty's as well, is that on the petition, he specifically put his address as a different place. So now he's trying to say he's a resident. And
Yeah, the point being, he had no legal right to get in there. All right, I'll mute and go back a second.
Just like
She said lived. I can hear it pretty clear.
Yeah. So you can play it however you want it to play it. I'm going to leave that up to you. One option would be to shoot them a text or anything, and like, just so you know, I'm going back to the house to pick up some belongings.
They would
say no, absolutely not.
I'm pretty sure they would show up.
Yeah. Okay. So what you may want to do is just go do what you got to do. I can't keep you from there, nor would I want to. It's your house as well. It's your property.
So it's technically the deed is in her name.
Sure. Sure. But you're like
obviously a resident of that house.
Yes, you have legal standing in there as far as the civil courts are concerned. You have keys, you have access. I know you live there. We know you live there. We're not going to stand in your way from collecting your property. If you go and do your thing, and just, if you get there and someone's there, we can, before you even go into the house, you know, you could call us and, you know, meet us over at the school parking lot area and be like, they're there right now. Can you send someone by to keep the peace? And we'd be happy to do that for you. We do that all the time. Especially if the roles are reversed. If you had been asked to leave the house, we do this all the time where, you know, the person who has resided there has a legal right to grab things.
Okay, yeah, I'm just gonna get as many friends as I can and get out of there as fast as humanly possible.
Yeah, so if you end up being there, and either if they're there already, my suggestion would be to kind of head over to the parking lot of the school, and we can break the ice, keep the peace, be like, hey, Justin has every right to grab his things, and
Okay.
you should cooperate with this, because it's just, why create more issues? I mean, it's not you live there too, with your baby and yourself for quite a bit of time. So we could break the ice first, if you'd rather just do it that way and hope that they're not there.
Yeah.
And then
Yeah,
if they
I'll do
show up
that
while
and
you're
that's
there, just try to keep cool heads and just call us, and we'll send someone right over to keep the peace, just
Okay.
don't even mention anything, and just or be like, the police will come down and we'll sort this out.
Okay.
I'm not trying to create any, more difficulties for any of us, and let's just call the police. They'll come down and help us.
Go deal with your baby.
Don't need to
All right,
butt heads.
perfect.
No, sometimes things get very emotional, and
Yeah, that's a baby who's waiting to be breastfed.
we can diffuse it a little bit if we just say, hey,
Okay.
let's all hang out for a minute, and we'll call the police to help us, tell us. And that's
Okay,
what we would
understood.
say. And what we'd say to the family is, you know what, we're just trying to, he has a legal right to grab what he wants out of the house. He resided here. The son's in his custody. So you got to grab the baby thing.
Does that include Kelsey's computer?
Right. Oh, by the way, your baby was waiting for breast milk.
Yeah. I mean, is this cop oblivious to the fact that there's a crying baby there with no mommy?
Yeah. Hit play. Let's finish it so we can discuss.
I'm sure.
Okay.
So, and if there is down the road, like any dispute on property, what we would tell her, like if she says, oh, my 50-inch TV's gone, he took it, we would just tell her that she'd have to take it up with probate court. And civil
Okay.
court.
Yeah, no, I just want my tools, my clothes.
Right.
I don't have any of my stuff, so.
Yeah, you have your weapons, I think. You have guns,
I do,
right?
yep.
Yeah, you have all
I
those.
removed those,
Yep.
them all from the house
Yep.
the night prior.
Yeah. So that any property, we would just take a report from her and say, talk to the courts, because that's not our purview.
Okay, understood.
So if you're not going to
Thank
give
you
them
very much.
if you're not going to give them a heads up, which is your right to, it's not my business to tell you what to do. That's not our jurisdiction, because you don't have an order out against you, and you have legal standing in that house. Just call us if you happen to see their car there.
Yep.
And we'll meet you before and break the ice with them prior, and then we'll go from there. And if
Okay,
they show
sounds
up,
good.
just call us. Just say, hey, I'm trying to get some property. Can you just send someone to keep the peace?
So even though I have a temporary restraining order right now, I am still allowed to go to that house?
Yeah, the restraining order is on her. Yeah, it's not keeping
It's
you
on
from
her,
going
okay.
back. Yeah. hmm
Okay, understood. Thank you for your time, and I appreciate it.
Okay. Okay.
All right. Take
You
care.
got it, Justin. Call back if you need any help, okay? And I
Okay,
really,
will
I
do.
do
Thank
feel
you.
for you. And, I know this is terrible, but I'm, a lot of us support you, and, we're all, it's terrible what you're going through.
Yeah, no,
so.
yeah.
Nightmare. And, I support you, and you're so kind to everybody. So anything you need, let me know, okay?
Okay, thank you so much for your time. I really
You got
appreciate it.
Yep. Take care. Bye-bye.
All right.
There, I made the sound again.
Wow. All right. That's all of them.
All right.
All of them.
So we'll go back to Lucy's point here. I do think that these calls could be relevant to that. And babe, your point about so we heard about those because, there's things that we covered that weren't in court, and there's the stuff we heard in court. So now I forget. We read that email, right? Was it an email or a text? An email that went out. But was that something we did outside of court? And we're talking about I think it was a Kelly, was what people said in chat, that it wasn't Katie. It was a woman named Kelly who sent that email that said,
Yeah, I'm
that
trying to pull that up. Where do you guys know in what filing the
you
emails
guys,
were?
I think somebody sent it to you.
Really?
Yeah, while we were like on the live.
Oh, yeah, I think you're right.
But Tracy, if she's listening, might know if it was attached to a
Wait,
pleading.
let me see. I think it was. Hold on.
But Lucy makes a very good point that Justin's calls should be admissible for state of mind of the officers' effect on the listener serving the RAs. Justin's warning about Katie's behavior may have had them trigger hyper. Very, very good point. Very good point. So Bob and I take back what we said before, and his calls, at least some of them, and the police's reaction, like you heard him saying, "Oh no, we didn't want to tell her. We didn't want to tell her because something to happen," and him saying over and over again, like, "This is so dangerous and you guys have to do something." But I think that was after, now that I'm thinking about this. At least that one. The one where he's yelling at them to come is after all of this has happened. But the one where he's talking to the one, I don't know if he was a lieutenant or whoever, where he was like, "Did you guys give him a heads up about that? Give her a heads up about this?" Um, that one would be relevant for just what Lucy's saying, that the effect on the listener. But definitely the emails. Are you still looking for them, babe?
Yeah, I'm not like I don't think it was via.
But those emails went out after because they were about what happened. They were about she shot somebody.
Yeah, that's true.
So
those
but
are
whatever
after.
whatever he said before, which had to be enough significant enough for them to be like, "Oh no, we didn't want to tell her in case something happens." And that first call before with him and the sister, I think those should be in play as well. And yes, Lucy, that means you're a lawyer now. Yes.
Nice.
But yeah, the
Yeah, I
emails
mean,
took place afterwards, so that I wasn't thinking.
yeah, I don't, and I frankly, I don't know how much they would affect the judge either way. Um, I mean, obviously, if to Lucy's point, I think that state of mind of the cops going in, if they're going in hot,
But here's
you
what I
know,
have to say though. Okay. So let's talk about like the bench and the jury trial thing. So we talked about like whether you take the stand and is it better, is it more likely to take it when there's a bench trial? You also have like the bullshit meter when you're dealing with a bench trial. Like you're not, and it might be like he's overly inclined to call bullshit on whether it is or not. But you've got the kind of two sides of this. We want to say he's out there overhyping this, making it sound like she's crazy, making it sound like she's dangerous. She wasn't dangerous. But then they get there and she is going to point a weapon at her head. So then that begs the question in what I would think like the judge's mind of saying, well, it sounds like everything they said was pretty much accurate because she went to the extreme of pointing a gun at her head. So she must have been really, really, out of it.
yeah.
So I don't think that it hurts her in that sense. And I think it makes it, more likely that she was, gonna point the firearm at herself. I just don't think there's any scenario where the judge could decide between her saying it was a move towards suicide and them saying it was a move towards suicide by cop. It's literally a he said, she said. And Bob and I talked about, and I'm sure that there'll be some of this, with the defense, but that your mind is going to recreate a traumatic event the way that you perceived it. And if you want to take the position, which I think with a judge is the best position to take, you do not want to argue to a judge that they're all corrupt. You just don't. because a judge is not going to want to rule and say, you heard him stick up for the prior judge. I think everything the judge before me did was 100% right. I would have done all of that. So you don't want to go in arguing to a judge that these cops are corrupt, that the prosecution's corrupt, that they're, that's what all of this is. You just want to argue that the cop, the partner, he perceived what he thought he perceived in a split moment. And that is what he thinks he saw. So that is what he will replay in his memory. And, I wonder with a bench trial, would it still be helpful to call a, trauma memory expert? It's too late to be announcing experts now, but I would have had such an expert prepared for a jury trial in this case that speaks to just that issue. And I think if you present it to the judge like that, where he can say, you're both good people, you're both right, or I can't tell you which, there's no way for me to know beyond a reasonable doubt whether this is the way he perceived the events. You don't want to lay too much on he has motive to lie. I think you want to frame it as he has motive to see it that way. And then, his brain is interpreting it that way because that's the way he wants it to be, because he can't, he didn't want to come to terms with the fact that he fucking got trigger happy and shot too early before he realized she was not going to point that gun at him.
Yeah.
But I do think, as to Lucy's point, that some of those calls are absolutely relevant, and what he told them are absolutely relevant to the fact that they were more possibly on alert that she was a danger to them.
Yeah. And I got an update. The Aaron Spencer trial has been reset to begin on June 22nd of this year. Aaron Spencer trial, which if you're not following that case, you should be, has been reset to begin on June 22nd.
And also somebody said, the virtual juror says the Richlands jurors spoke on GMA. We might need to start a new live if we want to cover
I got to
that.
record with Lauren.
I'm just saying in general. We got some new members. I'll list them out and then you can give them all hugs. We've got Nursing the Truth, ER 94, Roy 94, who also gifted 5 memberships.
Oh, thank you.
Thank you. We've got Michelle Claudil. We've got Gen X Jenny AM. We've got
I am.
Sorry.
Gen X Jen, I am.
Got it. M Shannon, Jessica 274Z. I don't know. Julie Jensen maybe had to re-up, but welcome back, Julie.
Yeah.
And
Love having
Anna Smith. Welcome to all of you. We appreciate our new members. What do they get, babe?
Aw, family hug.
Welcome to the
family. From what I've heard, negative. Spencer will not be streamed. What I did hear is that the new judge, is going to allow for an overflow room where they will have closed circuit TV in there in case there's too big of a crowd for everybody to fit in that rather small courtroom. So that's good. I don't think he's just inclined to stream it. So that's what I've heard from pretty reliable sources.
The revolution will not be televised.
Oh, I like what you did there, babe.
RALB sent a super sticker. Thanks for your generosity.
Rauld.
Lieutenant Detective Tully Tubby, thanks for your continued support. 7 months. Just want to say I'm lurking, but always here.
Thank you, Lieutenant Detective. We love you.
Law ZC gives a suggestion. Use earbuds. It's easier to hear when it's low.
Oh, yeah.
And Sleepless Sleuth points out that used a weapon, and she's been a member for 12 months, babe. Thanks for your generosity. And now you can highlight that other post.
Sorry, baby.
It's okay.
We read the text on the last live that we did, the last Kelsey live.
No, we didn't have those texts. We didn't have Justin.
Kyle sent them to me. and I cannot for the life of me read what they say.
Oh.
Oh, wait. I take it back. He sent me much better quality. Oh, Kyle, it says I'm requesting access. So I need access to whoever's Google Drive that is.
But you got to do it on your computer. You're going to have to request access because you can't share from your phone. Hold on. Stand by, Kyle.
Oh, yeah. Oh, yeah. All right, hold on. Oh, yeah. Okay. Let me see here. All right. So I will do this. Just a viewer. I'm just gonna view. I don't know who. I don't know who can give access. Probably whoever, just the owner of the
Sent it
Google
to you.
Drive.
Whoever
Yeah.
just sent it to you.
Oh, well, Kyle sent it to me.
Right. So he should get like a notice, but he might get 2.
Well, I mean, he's here. Kyle, do the good work. Do the good work. Yeah, I mean, they would have been smart to do that. They would have been smart because I'm going to be up in that ass down there. Yeah, we're going to have when we get down there, we're going to have a nice town hall meeting with the good citizens of Low County. I had quite a few people reach out to me because what we wanted to do is set up a room with a bunch of citizens, just talk to them, see what their view, see what the people that matter, the people that live in that county, in that town think, about these charges, about Aaron Spencer being tried for this. I mean, I think it's going to be pretty evident. Like, I don't think I'm like really making much of a guess in terms of saying I think they're going to be very much in support of Aaron Spencer. The fact that he won the primary is a pretty good indicator of where that particular
Yep.
town stands on that issue. All right, let me see if okay. All right, let me see. I gotta rotate this shit.
It's all of a sudden really hot down here.
Hot town, so I'm in the city. Back of my neck feeling dirty and gritty. How do I rotate, babe, on Google Docs? Do you know?
On Google Docs? I don't know.
Oh, yeah. Google Docs.
In view somewhere, I would assume.
I'm looking. Anybody that's not a tech moron, can you help me? Can you help me?
Kyle's oh no, he's probably talking about he gave you permission. Under view, there's usually something.
I'm
Rotate,
looking at view. There's
landscape.
always show. I've got the full toolbar. Oh,
Can you
wait.
change
Hold
it to
on.
landscape?
Oh, hold on. Tools. View. Oh.
They're saying download. Can you download it to a PDF? So you can do what you want.
Sounds like a lot of work, bro. Sounds like so much work. All right. Okay, downloaded that one. Downloaded that one. Downloaded that one.
Everybody's saying download it. He's doing it. He's on it.
Doing it. Against my will. You guys are lucky I even know how to do that. I am.
Come on.
I don't understand. What do you mean download? All right, let's see. Okay. All right, let me see if this helps a wee bit. Let me see if this helps. Okay. All right. Okay. Okay. Oh, yeah. Oh, wait. Oh, boy. Okay. Hold on. I'm going to do the work to rotate the view on all of these. It's going to take a while. It's going to take a while. I went the wrong way on that first one. I'll figure it out on the next one, though. I have to go left instead of right. Okay. Speak while I'm doing this. Just stand there like a statue.
I don't know.
I don't know.
I was going to
Make
talk
words,
about
woman. Make
I was going to
words.
talk about what you should, the way you should do it, but I don't want to make it any harder on you.
Yeah, don't make it last any longer than it has to. Okay.
Light is Kelsey, dark is Justin once we're looking at these texts. So thanks, Kyle.
Good.
Thank you.
Now, of course, they're probably going to be, are they all out of order, Kyle? So everybody's going to be telling me, I can see the dates. You're going out of order, Bob. There's no context. They're all out of order.
Probably start at the bottom. So I'll read the, what do we say, which is dark. Kelsey is light. So
wait, I have to be Justin. I don't like it. I'm playing under protest. That's what's happening there. Okay. Okay. All right. I got them all set up. All right.
I'm
So
spelling Fitzsimmons with 2 T's. I did that in my.
Fitzy.
I think I did that a bunch of times.
All right. So let me see. So this one's at. I can't even tell what the hell. It looks like. Oh, I can't even make out. Maybe 5:22 a.m. June 30th. Let's see. 5:23 a.m.
Thanks, nursing the truth.
5:23. All right, so I think this one's they all say. All right, you guys just tell me in chat. Like I'm just throwing it up. We're gonna roll with it. If it's the wrong time, then or if they're in the wrong order, let me know. Let me know. I did not just start singing like a virgin. Okay.
He was singing in My Morning Jacket song. If you know, you know.
And then before that, it was Hot Town, Summer in the City, back of my neck feeling dirty and gritty. All right. All right, wait. Oh, hold on. Oh, okay.
Yeah, so these are the texts that they discussed in court today.
Okay, so I'm starting from bottom.
Yeah, as you should.
Okay, so you said Justin's in black.
Yeah, so I go first.
Can you read that?
Just wait. Now they're at the aren't.
No, you stop. You just woke me up. It's the very top there, love.
Oh, you just woke me up to let me know I have to bring Caden to work with me.
You were not listening then. I will happily pick Caden up and watch him at work. I said I didn't want to be in the house at this time. You have to respect that. You were choosing to not have me watch him and bring him to work.
You're not a babysitter. You're his dad. This is our home where the three of us live.
Okay, and the date on this is June 30th. It's hard for me to tell. It looks like it's 5:23 a.m. And by being his dad, I will watch him and pick him up if you wish.
You're not a babysitter, Justin. You don't, quote, watch him. You can simply just come home and be home with him. You know the home where our family lives?
You know the home where our family lives?
Right, I realized.
Come on, you're not on
I
point.
realized it afterwards, sorry.
Okay. Right now, Kels, those are the options. I will and can pick him up to be with him while you were at work. But you were choosing to bring him to work. You have to respect that I need space and time and will not be entering the house alone.
Your space is abandoning your family. I don't understand why you can't come in our house and you won't explain it. I will not be single parenting for days and days on end.
When you strike me in the face several times and physically assault your best friend, Kels, you set the tone. I am reacting in the best way possible to find a way forward, and this is what I need. It is not about what you need anymore. We need to be the best parents possible, and I cannot do that in the house at this time.
Just not even true, but okay. Abandon your son. I forgot everything that comes out of Katerina's mouth is the truth, right? Good luck to you.
And Cassie and Deandra and Michelle all lying.
You're missing valuable days with your son you will never get back by your own choosing. You're making me a single mother and your own choosing.
You're making me a very single mother by your own choosing.
Oh, geez,
Context
sorry.
clue.
You're making me a very single mother by your own choosing. I'm rescheduling Caden's surgery right now. I will not be doing this alone. Is that the rest of that still going? Answer.
Yeah, there's no
Okay.
other text.
Answer the phone. Sad you let your feelings towards me affect your son. Poor kid.
All right, so wait, this looks okay. Wait, that's the same shit.
Does it end the same way?
Wait, what? Are these all the same damn texts? Kyle, did you
Wait.
send me 8 of the exact same messages?
Wait, go to the end. Let's see.
I did go to the end.
Oh,
They're all the same. Is that all of them, y'all? Is that all of them?
that might be it.
I mean, it was all wow. So I went through all the work of rotating these images, downloading them all, and they're all the same messages. Is that all of them, y'all? I'm just kidding, Kyle. It's the thought that counts, baby.
Yes, thank you.
Thought that
Thank you.
counts. So this is all of them, though, right? No, there's like 4 pages. All right, well, I'm not seeing them, Kyle.
Well, did you check all 8?
Yeah, I think. Let's see. Oh, wait, what in the wide world of sports is going on here? Hold on. I take it back. I don't know why it put up the same damn message 8 times when I downloaded it.
All right, this one's June 30th at 2 a.m. So this is before those. What?
Wait, are you seeing it?
Well, now you just switched to like emotion.
Wait, hold on. I got to download these. I'm seeing different things. Okay, so there's that one. Okay, so wait, that one? Okay, that one. All right. Okay, this one. Oh, oh yeah. Oh yeah.
All right, Bob's found them.
Okay. Oh yeah. What in the wide world of sports happened there? Seriously.
I don't know. Now there's emotion up on our screen that we see.
I know. I'm doing the work. I'm doing the work over here.
Okay. And you have to remember when he's sending these texts that we're reading, he knows he's about to file this motion. So like we're always telling clients, like you don't write a text in any tone that you wouldn't want a judge to read. You write it as though that the person on the other side is reading it. So he has motive to say whatever the fuck he wants in these texts right now. That's not a fair representation of like a real conversation, because we already know from before this that he's like, well, can I get baby now? Even though I haven't even filed the motion yet. A petition, sorry, for a restraining order.
All right, let me see here. Okay. All right. I'm going to try this again. Let me try this again. Okay. Oh God, I got to rotate everything again.
Usually if there's something on the side here, see over
Yeah,
here.
it's all the same. I am so confused.
On the far, okay, look, listen to me. On the far right, there's what looks like 2 pieces of paper. Click on it. On the far right, those little pictures.
What are you talking about? Where?
These little, I can't show you, all the way to the right, close to the comments, like you're going to the comments. There's a little tabs there.
Okay, over here.
Nope. Go like you're touching the comments. You see a
What
pen.
comments?
The people's comments, the actual people's comments.
Oh, you mean in here?
Yeah, but now right next to it, you see the pen, you see the 2 pieces of paper, you see the bookmark. Oh, God.
Yeah.
So
wait,
click the pieces of paper.
I don't see what you're speaking of.
Oh my God. Right next to it's closest to the comments on the page. Closest to the comments. Do you see view summary?
Are you talking about in StreamYard or on Adobe?
On Adobe. Do you see the words view summary?
Yes.
Okay. Next to that, there's 4 or 5 pictures. There you go. Click on the one. There you go.
What I'm trying to tell you, babe,
is
that everything that I just downloaded, that I went into Finder, sent over to Adobe, is all the same thing again.
Oh, it's
All
not the
the
right.
right,
Oh.
you're not
Oh, I
understanding.
thought you just were trying to
Right,
rotate
look,
them.
here, I'm currently going through all of them, and they're all the same damn thing.
But we saw ones from 2
I
something AM.
Girl, I don't know what to tell you. I don't know what to tell you.
All right.
I mean, if I could just pull the Google Drive up, we could, like, there's gotta be a way to rotate it where I'm not. I don't feel like necessarily doing this during a live.
All right, we'll figure it out. We'll read it
We'll
on
figure
another
it
day.
out, we'll figure it out. I can't turn the page.
You can
man.
turn it, but you're saying it's all the same, so we don't need to turn
It's
it.
not if I pull up the Google Drive.
Okay, but I'm
If
just
I
talking
pull
about
up
they're talking about turn the page in this, which you could do very easily, but it's not the right thing, so you're not.
Correct. What I'm
Right.
trying to tell you all is when I'm downloading the document from the Google Drive to my computer, it keeps downloading the exact same one. It's not downloading the one that I'm actually. It's weird. I don't know what else to say.
All right. All right. We'll deal with it another
It's
day.
not a. I mean, I'm sure it's my fault somehow. Yeah, it's all the same shit. It's all the 11/115/055.
Try, so on the Google Drive, try what DB is saying on the Google Drive
I
document.
don't know. Like, I am not looking at. You got to
Press Control, Shift, and minus.
Okay.
Might be Command on a Mac. We're on a Mac, DB.
Control minus.
Shift and the minus. It's up on the right,
Yeah,
under the 10.
Under the 10.
Yeah, he's not in Adobe. He's trying to do it in the Google Drive.
This is
So
Google
just forget
Drive.
it. Yeah.
Oh wait, here. Let me try this. Oh my God, I figured it out. Maybe. Maybe. I don't know. All right. So here, let me go in. Let me see if I figure it out.
We're not doing it, or you are doing it.
I'm trying to, I think.
Because once you're in Adobe, I can talk you through doing it.
Okay, well, I think this is it in Adobe. I think. I don't know. Yeah, this is in Adobe. So talk me through it.
Okay, so it's this screen right here that we're looking at now. So
Wait, hold on. Hold on.
Click the piece of paper thingies that I said before, the double pages, second to last little button.
See, this is what you get if you guys want me to pull some shit
All right,
up.
just listen and do it.
All right, hold on. Man, you are bossy. All right. Okay. I'm over here.
Go ahead, click the piece of paper looking with the 2 pieces of paper.
This?
I don't think you're sharing the right screen with us.
Okay. Let me try to share this then. All right. Okay. All right. So
Okay. So up at the top, click the one that looks like a grid.
Here?
Yeah, because I don't see the multiple pages. Okay, there you go. See the arrows?
Oh yeah. Oh yeah. What is this shit? See, I'm not in my Adobe. You know what? I'm like over this shit.
Okay.
Like it brought me to some like rando Adobe instead of mine. Ay, ay, ay.
Because it wants you to sign in. All right, just forget it.
Oh God. I'm not doing that now. Like, I
Why
don't know what the hell
why
my
are you
password
not signed in?
Whatever. Yeah, exactly. What are we doing?
All right.
I don't even know what I've been signed into Adobe for like 2 years. I have no idea, and I'm not trying to figure it out. All right, so that's it. I got to go record it with Lauren anyway. So, we apologize. I'm going to clip all of that clunky shit out of the replay crew. I'm not really. You're just going to have to skip it.
No, I think we should.
When you get to it, just, end it. All right.
But
So
they won't hear this until after they're at the end. So
yeah, the big takeaway from today is obviously bench trial. Huge call. Huge call. I think it's the right call. Only time will tell. Only time will tell if it is or it isn't. But you guys are amazing. You guys are absolutely amazing. We love you, mods. Thank you so much. We still have that read thing. I've got to get back to Zach Adams. I want to make sure that we finish that up here in the next week or so. Other breaking news, Aaron Spencer's trial has been reset for June 22nd of this year. We will be there with bells on, unless they decide to stream it, and then we don't have to go. But I actually want to go, but I don't know. All right, you guys, thank you so much for all your wonderful support. If you're new to the channel, please make sure you like, share, and subscribe. If you're on replay crew, please leave a comment. It helps get us out into the algorithm. We're always trying to grow the channel, so spread the word to your loved ones, your friends, your family, all that good stuff. Because remember, without you guys, I'm quite literally just an old man
sitting around talking to his wife.
Thanks, y'all.